direct her, my lord, to supply a copy of the class 10 mark sheet, my lord, to Mr. Ratul Vishwas client, my lord, Robindra Mukto Vidyalaya, to verify. My lord, I don't know whether it was served or not, whether it was verified or not. But my lord, I am not on that. My lord, kindly recall, my lord, one thing. That is, my lord, your lordship was pleased to direct to produce the earlier writ petition, where, my lord, my representation was deposited by me, my lord. And there, my lord, thereafter, the Honorable Justice Amit Talukdar was pleased to pass reasoned order according to that representation. And, my lord, according to that petition, according to the representation, my lord, the reasoned order was passed by the DM, and I am challenging that. So, my lord, I am not on his mark sheet, my lord.
No, your entire case proceeds on the premise that she had obtained a forged certificate, and based on that, she had got her
My lord, I am
appointment.
grateful. That is, my lord, class 8 certificate, my
I
lord.
ask you to take any submissions.
My lord, that is, my lord, absolutely correct, my lord. I am grateful to
I have
your lordship,
recorded
my
that
lord.
already.
My lord, I have submitted that her class 8 certificate is fake. And, my lord, it is not from the birth submission. It is, my lord, from the record, my lord. Just, my lord, for your lordship's convenience, I am reading the earlier writ petitions, my prayer.
So her
Upon
class
which,
10
my lord,
pass certificate is not
no,
fake.
my lord, that is genuine, my lord. I have stated that is genuine.
Wait, the matter is going on. District magistrate will decide.
No, Milord. The same matter, Milord.
I know district magistrate will decide pending disposal. I am hearing this matter now. Wait.
My lord, kindly, my lord. My lord,
It is expected that the district magistrate will wait adjudication. The matter is going on here, and the matter has been restored.
No, that's why I mentioned
No, the matter, the writ application was previously not restored. Today, the writ application has already been restored. I am hearing the matter. No, there is no necessity to issue any directions at this stage. Let me understand the situation. Let me understand what the petitioner's case is.
my lord, my case is, my lord, I am not on that, my lord, class 10 certificate. My lord,
Let us see what is your case in the petition.
My lord, earlier writ petition upon which, my lord, the Honorable Justice Amit Talukdar was pleased to pass an order, my lord, considering my representation. Your lordship was kind enough to direct the department.
Do you want this court to decide this issue completely, or do you want the district magistrate to take a decision? Make up your mind.
My lord, kindly see your lordship's order, my lord.
I have seen
Talukdar's order, my lord.
Yes.
36 of this writ petition. Kindly see, my lord.
Yes.
Upon which reasoned order was passed. Second page, my lord. Page 37, my lord. My lord, middle portion. In the light of the aforesaid situation, the court is of the concerned view that.
What is the situation? Let us go prior there too. In support of
My lord,
paragraph 1.
Paragraph 1.
Yes, page 36.
My lord, may I read from paragraph 1?
Yes, naturally.
My lord, I am reading, my lord. I am grateful, my lord. Petitioner is in a second position in the list of appointment of auxiliary nurse and midwife in the Nanapara High School, such and such block in the district of such and such. Her grievance in this writ petition relates to the candidate of respondent number 14, who, although did not have adequate qualification, ranked first in the list, was accordingly selected.
So, what is your contention? She did not have qualification.
My lord,
now read.
My lord. In support of her claim, she has taken out a supplementary affidavit showing annexure A that qualification of the respondent number 14 was not genuine. Accordingly, it has been prayed on behalf of the petitioner that respondent number 6B directed to look into the same in the terms of the representation made before as appearing as annexure P2 of the writ petition. In the earlier writ petition, it is, my lord, annexure P2 of the earlier writ petition. May I read it, my lord?
Continue. Learned advocate
appearing for the respondent number 1 does not have objection and submits that the settlement
statement should be verified as to whether it is a correct one.
My lord, I am grateful, my lord. তারপরে কি serious objection has been raised on behalf of the respondent number 14, questioning the
genuineness of annexure A to the supplement.
Genuineness of annexure A to the.
Who is the respondent number 14?
Respondent number 14, my lord, private respondent, my lord. And my lord, she also raised a question as to how the inquiry report comes from the end, the petitioner, and not from the state respondent. He is apprehensive that the representation is directed to be considered by respondent number 6. Process of his client's appointment would be stalled, which is already been affected by the virtue of the pendency of this writ application. Next paragraph. In the light of the aforesaid situation, court is on the considered view that even though no decision should be taken without investigation into the factual maxim in the I8 in the particular fact situation, the instant case is possible, and the respondent number 6 could be delegated at first look into the grievance of the petitioner, which is annexure P2 of the writ petition. It is a matter of regret that, notwithstanding in the first that the same fact that the same was made before the respondent number 6,
He did not consider the representation directed to consider.
this is, my lord, what was the
So
subject
your
matter of the
grievance, what is your
consideration?
grievance? What is
My
your
grievance is a subject matter of the
no? Your
representation.
grievance is that the private respondent did not have adequate qualification.
My lord, I'm grateful.
What is the adequate qualification?
That is, my lord, class 10, class 8,
Or
My lord,
class 10, whichever.
or class 10. My
Now
lord,
let us find out whether she has adequate qualification or not.
in class
As
10,
on
my lord,
date of making the application, certainly as on the date of making the application, whether she
my
has
lord, kindly consider my submission.
yes.
My lord, kindly recall, my lord. Your lordship was pleased to direct the department to bring the record of the earlier writ petition.
Everything
Lord,
has been produced. Everything is
My
there.
lord, my lord, it is produced, but my lord, I am placing that representation. Upon which, my lord, Honorable Justice Amit Talukdar was pleased to direct, my lord,
The
the
court
DM to
has.
take a decision.
You cannot now step back, sir. You cannot now, Mr. Chowdhury, you cannot today step back from the decision taken by a coordinate bench of this court. What is the decision? The coordinate bench of this court has identified what is your grievance and specifically recorded that according to you, sir, your learned friend's client does not have adequate qualification.
My
Correct? And having regard to that, your grievance was rejected to be considered. Because you said that she has proceeded to get appointment on the basis of a certificate which is forged. Now that was only class 8 which had proceeded.
My lord,
She shows us genuine class 10 pass certificate.
my lord.
Matter ends there.
My lord, may I
Matter ends there.
My lord, may I
The
humbly
more you
submit one
press,
thing?
I will be compelled to decide the entire issue.
My lord, may I submit only one thing?
Yes.
My lord, at the cost of repetition, my lord, most humbly, my lord, I am placing, my lord,
I cannot act mechanically by simply
My lord, your
directing the
lordship was pleased
authority to consider a particular certificate,
My lord,
whether the
your
same is
lordship-
genuine or not,
My lord,
without taking
if,
up
my lord, I am
pragmatic view.
asking myself, my lord,
Yes.
if, my lord, my Madhyamik degree goes, my higher secondary goes, my graduation goes, my lord, how can I obtain
She-
LLB
no.
degree, my lord?
They will verify her Madhyamik degree. She will verify her Madhyamik degree. They will verify. If she ultimately found, yes, miss, you are there.
Yes, my lord.
You are also appearing. Yes.
I am for the state.
Yes,
my lord.
yes. Tell me.
My lord, the disseminator, my lord, sent me yesterday, WhatsApp, my lord. The issue is same. My lord,
District magistrate has proceeded with the matter.
yes, my lord. The 8th of February, date is for hearing, my lord.
I will hear it after that. Let him decide the matter then. I will decide hear after that.
My lord,
Let I keep it pending. Very well. Very well. I'll keep this issue pending.
as well,
Let him decide that.
আল্লাহ। দেখি দাও আছে আর?
copy now.
ঠিক আছে ঠিক আছে এটা দেখো তো কি আছে।
He has to wait. The matter is going on here.
But issue is the same, my lord.
So therefore, can he proceed in the meantime without this adjudication?
As per law,
I'm not directing anything. I'm saying the matter is going on. His writ application has been revived.
my lord, it
I
has
will
been,
hear the matter.
my lord, it has been please pass with the order of the my lord.
He was directed to consider.
The honor just to
Now, today, the situation is absolutely different. Today, the situation is genuinity of a certificate.
Yes.
Now, that genuinity of certificate, district magistrate will decide. He has to decide, he will decide. I will record that, what certificate is to be taken into consideration by her.
My lord, kindly direct me to class 8.
Why
maybe
will I
consider-
direct class 8? Your allegation is
Class 8, my lord. My lord, kindly see.
not having requisite
False
qualification.
certificate.
My lord,
Not having requisite qualification.
my lord,
Therefore-
kindly read the order, my lord.
I have read the order.
Recent order. My lord, kindly see the recent order. Page 42 of my petition.
Why are you trying to be so mechanical, sir? Try and understand the situation. Mr. Choudhury, try and understand the situation. Is he not qualified? That was your grievance. If he is qualified, you cannot stall her appointment.
My lord, he is not qualified as per my humble submission is that if class 8 goes, my lord, class 10.
From where did you get that certificate? From where did you get that certificate?
Class 8 certificate.
From where did you get that certificate?
My lord, kindly read this, my lord, recent order, my lord. It is for which I am challenging, my lord. Kindly see, my lord, page 42, earlier district magistrate order, which is under challenge. She has also told, my lord, that, my lord, class 8 certificate is fake. My lord, kindly see, it is DM's order, which is under challenge. Page 42 of this.
Then you ought not to have moved this application.
Kindly, my lord. Kindly.
Then you ought not to have moved this application. A genuinity of a certificate, class 8 certificate, how much does it matter now?
My lord, if class 8 goes, my lord, if my Madhyamik goes, my LLB will also go, my lord.
How Madhyamik goes? Madhyamik is genuine.
My lord, I am.
Let me see that certificate. Let
I
me
am
see that.
stating, my lord, myself, my lord.
Ajay, let me understand this. Let me see a certificate. Where is?
My lord, kindly come.
Now you are not questioning this certificate. This certificate you are not questioning.
Class 10 certificate I am not questioning.
And you are questioning 8.
I am questioning class 8 certificate.
How
Upon
strange.
which, my lord, accordingly, my lord, class 10 has no legs to stand because if class 8 goes, 10 will automatically go, my lord. It's automatic, my lord. If class 8 goes, 10 will.
What was external candidate, internal candidate?
External candidate.
External candidate.
External
Malad,
candidate.
their qualification.
If class 8 goes, my lord, class 8
advertisement.
class 10 will automatically go, my lord. He has no eligibility to sit in the class 10 examination. Well, it is very natural and common thing, my lord.
Give me the Xerox.
My lord, kindly take page 42 of my writ petition. My lord, I think, my lord, it is genuine. I have no objection. But if class 8 goes, my lord, class 10 will automatically go. If my Madhyamik go, my lord, my LLB degree will automatically, my lord, it will be
Yes,
vanished.
sir. What is the procedure for appearing before Rabindra Mukto Vidyalaya? This Madhyamik examination? What is
He has to
Let me understand
qualify.
from the state. Let me understand.
Because he is appearing for the Rabindra Mukta Vidyalaya, my lord.
Very well. You just indicate to me what is the procedure for appearing
My
before
lord,
the
I am grateful, my lord. I am
Indicate.
grateful.
Whether any external candidate can apply. For
I am
Madhyamik.
grateful, my
May
lord.
I submit, my lord?
Yes,
My lord, I am
sir.
grateful.
I will hear it from the state, madam.
My lord, in earlier occasion, your lordship directed me to serve the copy of this mark sheet to my handover to my learned friend.
Yes.
I handed over.
I will record that submission of his today.
And
And I'll retain it on the file. But since Ratul Biswas is not there, I
Alright,
should give
my
an
lord.
opportunity to
Alright,
Ravindra.
my
And last occasion, my lord, I also submitted that his.
I understand this.
My
Sir.
lord,
There is no
page
difficulty.
27, page 27 of the writ application. This is the qualification for appearing as second AMA.
I have recorded your submission
Yes, my
in the order. Have you seen my previous order?
no. Specifically,
You have not seen the previous order.
Madhyamik. My lord, Madhyamik, I already passed. For that reason,
That is he has another grievance. He has another grievance. I'll check out his grievance.
class 8.
I'll check out his grievance from whether what is
kindly.
necessary, what is necessary, what is the necessity for appearing in an open university, open board exam. This is an open board exam. You are an external candidate, not an internal candidate. Whether any person can go and appear or unless that person obtains XYZ.
My lord, I am grateful, my lord. I am grateful, my lord. I am grateful, my lord.
Can my lord decide the issue back in which I
Let them
supposed to
come
one
forward,
time?
madam. Let them come forward. Your qualification is there. I will record that.
Yes.
I have already, you have not seen the order.
All the
You have not seen the order, previous order?
Sign.
My lord, in previous order, your lordship was also pleased to, my lord, noted that, my lord,
Madhyamik person.
the matter was last order is, my lord, accordingly, the petitioner, the private respondent has not even passed class 8. It was my submission was also recorded last occasion.
Why will I not record your submission, sir, Mr.
Fine.
Chaudhary?
I'm
Everything is recorded. So,
My lord, I'm grateful, my lord. So, my lord, last occasion I also, my lord, challenged class 8. Today I am also
appearing to a
challenging class 8.
constitutional court, so all your grievances will be considered. Wait.
I'm grateful, my lord. I'm deeply obliged. I'm grateful,
If
my lord.
anything is
My
there,
lord,
in your
grateful,
grievance,
my-
I'll consider that.
My lord, grateful, my lord. Kindly examine, my lord.
Miss Dabul, Dabul. Miss Dabul, learned advocate representing the private respondent. Now, in terms of the order dated 17th of January 2024, Miss Dabul, learned advocate representing the private respondent, has produced the Madhyamik examination pass certificate issued by the Robindra Mukto Vidyalaya, West Bengal State Open School.
My lord, Xerox copy, my lord.
Produced, produced. Originally, you produced, madam, where is the
Yeah.
original? Pass certificate and the mark sheet. The admit card, ওখানে আছে admit card, the pass certificate and the mark sheet. Let a copy of the aforesaid pass certificate, mark sheet and the admit card as issued by the Robindra Mukto Vidyalaya, West Bengal State Open School be retained with the record. Full stop. Since an accommodation has been sought for on behalf of the respondent numbers 9 and 10, let this matter stand adjourned and appear before this.
My lord, kindly record my submission also, my lord.
No, I will.
Last
On
occasion
the
it
last
was
occasion it's
all
recorded.
record.
Already there.
Hi, my man.
So I'll just hear out what Mr. Ratul Vishwas has to say. সামনের সপ্তাহে যে কোনো একদিন বেশিক্ষণ লাগবে না, এটা তো তুমি মেনশনে আছে। হ্যাঁ, যে কোনো
Before 8, my lord.
there is no urgency. You will pray for an
My lord,
adjournment.
kindly keep it on this Friday, my lord.
No, Friday I do not take.
Friday.
These matters are not taken.
This Thursday, my lord. Day after tomorrow.
We will be there on 8th itself, Thursday, next Thursday.
Next Thursday.
Next Thursday.
My lord, any day after 8, my
ফেরত
lord.
দিয়ে দিই।
Milord,
Email its own position.
এটা ফাইলে রইল
Milord, kindly clarify that, Milord, what you will, Milord, what is the basis of
He
appearing?
asked for an adjournment. He
Milord,
says
can I be
these are
after
not
8th, Milord?
necessary.
Milord,
Milord,
just
can
now it was fallen.
If I find
Milord,
out
just
anything,
now, just
Mr.
not.
Mr. Chaudhary, if I ultimately find out that there are irregularities in issuance of the certificate, in issuance of the certificate, I will take adequate, I'll issue
Milord,
adequate
just
protection.
now, Milord, for my
But
side.
unless you see, question is whether there are irregularities in issuance of the certificate. That for that, if I have to, then I have to
Milord,
direct.
just now, Milord, it was
Yes.
fallen from your lordship.
Yes, he will
That,
take
Milord,
instructions.
your lordship was, Milord, she
No,
will
the
take.
answer is why will I at this stage say nobody has challenged this? Let them come and say if they say that there are irregularities in connection with issuance of this particular certificate.
Nobody will come before your lordship for this irregularity.
They
I
are
am the
there.
petitioner, Milord. I am with that, Milord, view, Milord.
why?
Milord, it
I have
was
not
just now,
recorded
it
your
was.
submission that you are not challenging this. The moment you do not challenge this document, matter ends there, Mr. Chaudhary.
Milord, I am challenging class 8's document,
You
Milord.
cannot challenge it if they have to say that there are irregularities in connection with issuance of the certificate.
Milord, I have.
How do I know which age certificate are you challenging? It's a genuine document. These documents over genuinity is concerned, nobody is questioning, not even you.
Milord, just now, Milord, if I am not wrong, just
very
now
well.
it was.
line you no, ওইটা ফাইটা দাও
Man, just now it was fallen
Mr.
from me.
Chaudhary, although he does not question the genuinity,
Milord, kindly do not.
I have to record this.
Milord, kindly do not.
No, are you questioning
Milord,
the genuinity?
I
Are you
am
questioning the genuinity?
challenging the genuinity of class 8, Milord. Kindly record
Yes,
this, Milord.
yes. Mr. Chaudhary, although does not question the genuinity of the Madhyamik exam certificate issued by the Robindra Mukta Vidyalaya, however, he submits that the aforesaid certificate could not have been issued since then
My
it
lord.
makes no sense.
Milord, kindly
He,
record.
however, only questions the genuinity of the class 8 pass certificate. তারপরে রাতুলের ওটা দিয়ে adjourn.
Not kindly direct her to take instruction. What
They
is the
will take
procedure?
instruction.
What is the procedure to appear, Milord?
Not necessary, yes, at this stage.
No, grateful, my lord.
Well, on the last occasion, there was a direction upon me to take this specific instruction, whether we want to proceed with the matter or we want the reference to be amended. Now, Lordship, the instruction is we want to proceed with the matter. Now, the question is that whether the learned tribunal was justified by not allowing an application for addition of party for the other respondent. Now, this question has to be answered. Lordship, while referring to the law in this regard, I'll be first placing the judgment passed by the Honorable Supreme Court in 1964-7 SC RAIR 1964 SC 17646. This is Port Chief Gabon versus Industrial Tribunal. AIR 1964 SC 1746.
Yes, which paragraphs?
Yes, madam. Paragraph number 12, Lordship. So concisely, this was laid down. Reverting then the question as to the effect of the power which is implied in section 18(3)(b), it is clear that this power cannot be exercised by the tribunal so as to enlarge materially the scope of the reference itself, because basically the jurisdiction of the tribunal to deal with an industrial dispute is derived solely from the order of reference passed by the appropriate government under section 10(1). What the tribunal can consider in addition to the dispute specified in the order of reference are only matters incidental to the said disputes, and that naturally suggests certain obvious limitations on the implied power of the tribunal to add parties to the reference before it purporting to exercise its implied power under section 18(3)(b) if it appears to the tribunal that the party to the industrial dispute named in the order of the reference does not completely or adequately represent the interest either on the side of the employer on the side of the employee. It may direct that other persons should be joined who would be necessary to represent such interest. If the employer named in the reference does not fully represent the interest of the employer as such, other persons who are interested in the undertaking of the employer may be joined. Similarly, if the union specified in the reference do not represent all the employees of the undertaking, it may be open to the tribunal to add such other unions as it may deem necessary. The test always must be, is the addition of the party necessary to make adjudication itself effective and enforceable? In other words, the test may be be would the non-joinder of the party make the arbitration proceedings ineffective or unenforceable. It is the light it is in the light of this test that the implied power of the tribunal to add parties must be held to be limited. So that is the test which is there. It's whether this has to be whether the complete representation from either side, either from the union or from the employer themselves, whether it is represented, that is the test that has to be examined by the tribunal. Number two, Lordship, that whether the non-joinder of the party would make the entire proceeding ineffective or uh, inefficacious. That has to be tested. This question has been considered by the Madras High Court in two reported decisions in P.G. Brooks and others. By necessary implications, give power of the tribunal to add parties. It can add necessary or proper party. It need not be the employer or the employee. In the particular case, the party added was the receiver, and it was found that unless the receiver was added as a party to the reference proceeding, the adjudication itself would become ineffective. Thereafter, Lordship, paragraph number 14, Radhakrishna Mills. This was the Madras High Court followed the earlier decision, though in this case the party that was the summoned by the tribunal had added to the reference by the state government under such and such the act. 15, the Anil Kumar Upadhyay versus P.K. Sarkar. A learned single judge of Calcutta High Court has accepted the same view. In that case, the trustees of the Provident Fund in question, who had not been implemented originally to the reference, was summoned by the tribunal, and the court held that the absence of the trustees, the award would have become negative. It would be noticed that in all these decisions, the implied power of the tribunal to summon additional parties in the reference proceedings is confined only to the cases where such addition appeared to be necessary for making the reference complete and the award effective and enforceable. Such a power cannot be exercised to extend the scope of reference and to bring the matters which are not the subject matter of the reference and which are not incidental to the dispute which has been referred. That takes us to the question as to whether the appellant is justified in contending Messrs. Hindustan Steel Limited is a necessary party to the present proceedings before the Industrial Tribunal and should therefore be added as such. Mr. Chatterjee has raised two contentions in support of the plea that Messrs. Hindustan Steel Limited is a necessary party. The first contention is that if it is ultimately found that the respondent's claim for bonus for the relevant year is well founded as a result of the contract between the appellant and the Messrs. Hindustan Steel Limited, the liability to pay the said bonus would rest with the said concern and not with the appellant. The appellant, according to Mr. Chatterjee, is a firm constituted only for the single venture for undertaking the execution of the work of construction and foundation of the civil engineering works at Rourkela. It has been engaged by the said concern of Messrs. Hindustan Steel Limited as its agent, and in that behalf, an agreement has been executed between the parties. Mr. Chatterjee referred us to some of the relevant clauses of this agreement in support of his plea, that the inliability for bonus, if established by the respondents against the appellant, would be not the appellants but Messrs. Hindustan Steel Limited. We do not propose to examine the merits of this contention because we are satisfied that even if Mr. Chatterjee's contention is well founded by the reference of the relevant clauses of the agreement between the parties, that cannot make Messrs. Hindustan Steel Limited a necessary party within the meaning of 18(3)(b). This contention raises the entirely different dispute between the appellant and its alleged principal, and such dispute would not be wholly foreign to the industrial dispute, would not be wholly foreign, would be wholly foreign to the industrial disputes, which has been referred to the tribunal for its adjudication. The next contention raised by Lordship, the only thing is that
Power is there.
power is there,
Limited.
the test is there, the test is that whether it is wholly foreign to the
Now you
industrial
show me
dispute or not.
that
Now, I will from the
show me
facts, I
facts,
have to
yes.
satisfy
law.
your Lordship that why I am raising this. Kindly,
It
Lordship,
is not an ordinary addition of party under the civil procedure code.
no, Lordship, this is the difference is this. This is kind of ordinary necessary party,
No,
but limited with
sorry.
this limit.
the
power.
scope
is
addition is limited to the reference.
and that has
So
to
the
be tested.
principles of civil procedure code to that extent cannot be made applicable.
The test is whether the entire industrial disputes, the reference subject matters under reference, can be decided without it or not without.
No, that is not the test.
Yes, that's why Lordship kindly come
No,
to paragraph
sir,
12.
yes, come back, show me.
Paragraph 12.
Yes.
The test always must be the addition of the party necessary to make the adjudication itself effective or enforceable. Effective or enforceable.
Has to be in relation to the reference. Cannot be divorced of the reference, Mr.
That's why
Chatterjee.
foreign. That's why. Kindly come to this. Now I have
You
to show
cannot
your
read
Lordship.
the judgment as a statute, Mr.
I
Chatterjee.
have to, Lordship, this too, Lordship.
At the end of the day, you have to, what is the ratio of the judgment you have to ascertain? Not as a statute, what it is indicated here,
No.
one particular line.
No,
You have to understand the
test
ratio.
always
Yes.
must be. The test always must be is the addition of the party necessary to make adjudication itself
Very well.
effective or enforceable.
Very well.
In other words, the test may well be the non-joinder of the party make the arbitration proceedings ineffective or unenforceable. It is in the light of this test, the implied power of the tribunal and parties must be held to be limited. So limitation is confined by two principles. One is whether ineffective non-joinder of the party make the arbitration proceeding ineffective.
That is the question.
And
Please read it properly. Please read this line properly,
Yes.
Mr. Chatterjee. That is the question. There is a note of interrogation thereafter.
yes,
The test always must be, is the addition of party necessary to make the adjudication itself effective and enforceable?
yes. In other words,
The test
test
may well be, would be ineffective
and enforceable.
and enforceable. In the light of this test, that the implied power of the tribunal to add parties must be held to be limited.
And that limitation is, Lordship, based on that, again, whether this something is foreign to the entire dispute or not.
Very well.
That has to be. Now, this, Lordship, now kindly come to the reference which is made here.
Yes.
Kindly come to page 76. Page 76.
Is you are appearing in this matter?
Yes, Your Lordship. I'm
Where
to
is
respond
Mr.
now.
De?
He's on legs.
Yes, yes, very well. You are there.
Lordship. Whereas the industrial dispute exists between Messrs. SB Pigments Limited, such and such, registered office such and such, and workmen represented the Coleman, this Ricket Coleman Workers Associations relating to under mentioned issue being a matter specified in the second schedule of the Industrial Disputes Act 1947. And whereas it is expedient that the said dispute would be referred by industrial tribunal. Now, therefore, such and such, the said Fourth Industrial Tribunal, West Bengal, shall submit its award to the state government. Now, the said Industrial Tribunal shall meet as such places and on such dates, and it may direct issue whether the suspension of the workers declared by the management of SB Pigment Private Limited from
Which
4/11
page are you placing?
2011 is justified for 76, Lordship.
Yes.
Whether the suspension of workers declared by the management of Messrs. SB Pigment Private Limited from 4/11/2011 is justified. What relief the workmen are entitled to. Now, Lordship, kindly come to the order impute.
No. Whether an industrial dispute exists between SB Pigments PVT Ltd and their workmen.
Lordship, which one?
The first part of the order.
Where's the industrial disputes between the SB Pigments? Dhatka.
This is in reference to the issues were in reference to this order.
I'm reading.
Issues were framed in reference to this, whether the industrial dispute exists between Messrs. SB Pigments PE Ltd Private Limited and its workmen, represented by Ricket Coleman Workmen Workers Association.
Mentioned issue being the matter specified in the second schedule to the.
This is the dispute. And the particulars of the dispute between these two parties have been identified and issues have been framed.
Yes.
The dispute is between two entities.
May I read it? Lordship?
Yes.
Whereas an industrial dispute exists between Messrs. SB Pigments Private Limited, Dhatka, such and such, the address is given, and their workmen, represented by Ricket Coleman Workmen Workers Association, SB Pigments Private Limited, Dhatka, and the workmen represented by Ricket Coleman Workmen Workers Association. These are two things. Lordship, it appears from the nomenclature itself, from the nomenclature of the union, that this is not the workmen of SB Pigments.
How do I know? No, certainly not. How do you say that?
Kindly
The
come.
order is very clear, and their workmen.
Kindly come.
No, do not make something which is not there.
It
Do
is,
not
may
make
I
it
read it? May I read it? Read it with me, Lordship.
Yes. Place it.
Whereas an industrial dispute exists between Messrs. SB Pigment, Central such and such, and Corporate Office such and such, and their workmen represented by Ricket Coleman Workmen.
So Ricket Coleman Benkaiser Association is representing their workmen.
Whose workmen? SB Pigment's
Correct.
workmen. Now, what is the history of this has to be looked into. Why this has happened? That is the important question here. That why suddenly the Ricket Benkaiser's
Kindly
workmen
confine your
union.
submissions. You have placed the judgment of the Honorable Supreme Court.
Yes,
Now
madam.
confine your submissions and show me that you passed that test.
I will
this
show.
court
That's why
can-
this is important.
Don't unnecessarily bring into certain facts which may not be relevant for the
So
present purpose.
the-
Because this court cannot travel beyond this order of reference.
that's why I'm reading from the order of reference
Yes.
itself.
So
So
show me that these are workmen which is the entity you wanted to add? Which is the entity you wanted to add? You wanted to add
Ricket
Coleman
Benkaiser
Company.
company.
Show me that this is a dispute between Ricket Coleman Company and SVP Pigments or their workmen. Matter ends there. That is why I gave you an opportunity to seek. Anyway, that issue is closed now. So show me from this that
Now, Lordship, kindly come to my written notes of submission.
no, I will not go through your written note. Why will I go through your
I've
written
already
note?
submitted.
Written notes
Affidavits have been exchanged in this matter.
Maybe, but show me from your pleadings. Those are unaffirmed copies.
Affidavits have been exchanged, Lordship.
I mean, yes, from the affidavit. Why will
will
I ask
show
you
from
to
the
go to
affidavit.
written notes?
I have mentioned it in the written notes. That's why, Lordship.
You show me from your pleadings. I will not go through your written notes as of now. No additional disclosures.
These are
Mr.
disclosed already.
Mr. Chatterjee, why will we enlarge the scope by putting in a written notes now?
It is there already. It's there.
No, written notes I am not relying on. You first place from your pleadings from the affirmed affidavit, whatever you have disclosed.
Yes, my lord.
Yes. Written notes I am not relying for the present moment.
So the question, this has to be, again, this has to be examined.
You had
why
filed an application. Let us understand things clearly. You had filed an application seeking for addition. Show me from your application what are the grounds. Show me from your application what are the grounds. Page 80 or 80 onwards. This is your application. What is this?
Yes.
What is this? This is an application.
The written statement on behalf of the workmen represented by Ricket Coleman Workmen Association. That is not the application. This is the.
So how could you change the cost title? How could you change the cost title?
Which cost title?
This cost title at page number 78.
78.
Yes. Not a party. Principal employer, it was not a party.
They were not.
No, they were not a party. How could you change the cost title?
Or you kindly come to the.
Where is your application?
109.
Yes. Yes, 109. Now show me what are the grounds in 109. Confine your submissions to whatever is there.
I am reading from.
Yes,
the
only
certificate.
109.
If your lordship wants to, I am relying.
No,
on that.
only 109. You show me 109.
I have read from the reference itself.
Yes.
Kindly come to 109. That the workmen are initially appointed by the Ricket Coleman Limited of the late renamed as Messrs. Ricket Benkaiser Limited. But their service subsequently was controlled and regulated by Messrs. SB Pigment Private Limited. As signed and affirmed by the principal employer with the contractor so entrusted by the principal employer.
Yes. Yes.
So this is a clear about.
Yes. Then
The association respectfully submits that the contract and conditions of the employment of the workman was such and such, revealing the unaltered position as it pre-existed with the principal employer Messrs. Ricket Coleman Private Limited in spite of the contractual agreement conferred to Messrs. SB Pigment Private Limited. The name of the company reflecting in order of the reference. That the association most respectfully submits before the learned tribunal. The principal employer, Messrs. Ricket Coleman Company Limited, was renamed as Messrs. Ricket Benkaiser India Limited to be an added party having its registered office, Messrs. Ricket Benkaiser Limited, address such and such. That your honor may please to grant the petition considering.
is it your case that the name of Ricket Benkaiser or Ricket Benkaiser PVT Ltd has been changed to SB Pigments?
My case
It is not your case.
It's there in the first paragraph.
Your case is something else. Your case is that you are employed by SBP and the Ricket Benkaiser is your principal.
Initially appointed by Messrs. Ricket Coleman Limited of late renamed as Ricket Benkaiser. Now subsequently was controlled by Messrs. SB Pigment Private Limited. This is my case. Ricket Coleman.
Where you controlled? Where is that line controlled?
First paragraph.
Controlled.
Subsequently was controlled and regulated. Third line.
Yes.
By Messrs. SB Pigment Private Limited.
As assigned and affirmed between principal
Employer with the contractor so entrusted by.
Very well. That is your case.
That is my case.
Very well. Yes. Anything else you want to add?
This is something they have also admitted. I'll show from there.
Nothing more than whatever is there, Mr. Chatterjee.
Yes,
whatever is there, you can argue to that extent. Nothing more than.
If anything is required.
I have to respond number
Yes.
2.
Just a minute. And what do you want to add from your written notes? Tell me.
If you kindly.
Do not show me anything which is not part of the petition. I will
No,
not go there. No pleadings from which is not part of the petition.
not at all. Will you kindly come to In the written notes, Lordship, page number 2, I'm reading it.
Yes.
It is specific case of the respondent number 2 as pleaded in written objection of the said application that the respondent number 3 has failed to transfer its office in favor of the respondent number
Where is all
2.
this? In the petition addition of party?
Lordship,
Where is all this in the addition of party?
Lordship, after this
No, I
matter was admitted by this court, affidavits were
No,
exchanged.
I cannot take it.
Then on the
I cannot take into consideration
to the
this.
Honorable Court.
So far as these statements made in the written notes are unaffirmed statements, not part of the petition.
Lordship,
Forming
these
part of
are
the-
from the documents.
No, I cannot.
I can show from their
Whatever is
affidavits.
in the application, I will consider.
Lordship,
Yes, they were. Yes,
they have given the affidavits. Kindly come to their affidavits.
Yes, flowing from the
Annexed
rest. Yes.
77 onwards, Lordship.
No. In response to your application,
I will come.
in response to your application, this
Page
is what I'm
93.
considering.
This is the written statement on behalf of the SB Pigments.
Yes.
Kindly come. Para 94. Without prejudice to the aforesaid SBP state as follows. SBP is not a contractor as stated by the workmen in their written statement filed before the Sergeant Judge. Inasmuch SBP acquired the business of the Ricket Coleman Company, they acquired limited are employees of the Ricket Coleman Company.
Apply to the addition of party. The main defense is a written statement.
I'm reading from that. I'm reading from the record. One by one, Lordship. Business Ricket Coleman Company Limited, the employee of the Ricket Coleman Company Limited stood transferred in the name of SBP. The transfer included all the benefits enjoyed by the employees and liabilities borne of the Ricket Coleman. Now,
This is your page 103 is your app.
And supported it.
I'm
And 94 is his written statement.
now, Lordship, one paragraph, then I'll come to 103. With reference to the contents of paragraph 21-24 of the written statement, it is stated company was constrained to issue the suspension of work due to the sudden and unexpected fall in the market demand and products of the company, in which the company had role to play. The company could not have continued with the factory keep open in as much
Yes, very.
regular overhead. Then, Lordship, kindly come to 103. Written objection on behalf of the SB Pigments Private Limited to the reply to show cause filed by the Ricket Benkaiser. I am one of the directors of the company above then. I am fully acquainted, Sergeant Search. Paragraph 4, page 105. With reference to the contents of paragraph 1 and 2 of the said reply, I deny that the application taken out
He's supporting you.
at Ricket Coleman.
He's supporting you. He's very clear.
Present
And
proceeding
where is
not
the, who is opposing you? Where is
112.
yes, come to that page.
100.
Someone is opposing you, let us understand. Yeah?
And my opposition is against the written statement of SB Pigmentation. SB Pigmentation, he has categorically said, contrary to the stand of my land defense client, that he is not a contractor. He is the owner of the factory. Ricket Benkaiser has sold the property to SB.
Let
Yes.
me hear Mr. Banerjee.
Yes,
I'll
yes,
come
that's
back to you.
Lordship, kindly consider
Why are you so
112.
anxious?
Huh?
Why are you so anxious?
Because my land friend is pulling the strings.
This
Will be
makes me
pulled.
reconsider my thoughts.
No.
What is there? What makes you so anxious?
Lordship, kindly consider 112. That will clarify the entire thing. I have stated the
Take your
facts.
seat, Mr.
I have stated.
Yes.
Lordship, kindly come to 114.
Yes.
Messrs. Ricket and Coleman India Limited, now known as Ricket Benkaiser India Limited Private Limited, states as follows. Messrs. Ricket and Coleman India Limited, now known as Ricket Benkaiser Private Limited, submits that the application dated 27/3/2015 is not maintainable since the said company is neither a necessary party nor can be considered. The petitioner company states that and submits that the instant case, since the said company is no way connected with the factory located at Dhatka, such and such, and rule such and such. The petitioner states that it is evident from the record that the instant proceeding that by an order of reference number such and such dated 7/1/2015, the appropriate government has referred following issues to this library tribunal for adjudication. Now, they say that your petitioner states it is evident from the issues under reference that aforesaid relates to the suspension of work of the factory declared with effect from 4/11/2011, when admittedly the said company was neither in control nor possession of the said factory under reference for all practical purposes. The material facts testifying absence of the connection between the factory under consideration and the company would be evident from following undisputed factor. By business transfer agreement dated 10/8/2006, sold the factory to Messrs. SB Pigments Private Limited, having its office at 41 Chowdhury Road, Kolkata, such and such.
Yes.
The copy of the said deed of conveyance dated such and such. It is pertinent to mention that this document forms part of the list of documents relied on by the company under reference as item number 1. By letter dated 21/8/2006, the company under reference informed the union about transfer of ownership of the factory to the Messrs. SB Pigment Private Limited, having its office at 41 Chowdhury Road, Kolkata, for 71. The material portion of the said letter reads as follows. With reference to the transfer of ownership of the manufacturing unit of ultramarine bulk blue powder business, duly notified by the joint notice dated 11th August 2006, it is again being informed to all concerned that ownership stands transferred to SB Pigments Private Limited. Now, ownership in respect of what? Lordship, kindly come to with reference to the transfer of ownership of the manufacturing unit of ultramarine bulk blue powder business, duly notified by the joint notice dated 11th August 2006, it is again being informed to all concerned that ownership stands transferred to SB Pigments Private Limited on slump sale basis with all assets and liabilities. The relevant portion of the said joint notice is quoted here and below. The employment of all employees will be treated as continuous and not interrupted by the transfer of ownership. 116. And their terms of employment will not in any way be less favorable than those applicable to employees immediately prior to the transfer of ownership of the said undertaking. Yes.
Next page, 107.
Yeah, again, you are getting anxious.
No, Mr. Noskar is asking
No,
what is
one
going
minute,
on. I told that
I will not.
petitioner is supporting you
You see,
and reading
I,
my.
Lordship want me to close it.
No, no.
If you want
I had asked you to continue, Mr. Chatterjee. I said that why is Mr. D getting so anxious on matters?
No.
I-
I am not
What
anxious.
is the anxiety of this subject?
I don't have any anxiety. Mr. Noskar told me, is asking me what is he is reading. I told supporting you. The petitioner is reading my objection. Nothing.
Anyway, Mr. Chatterjee, continue.
I am very candid in my thought. And
You're
in my
candid.
words.
Yes, Mr. Chatterjee. Whatever is in the matter, Mr. Chatterjee, rest. While you are arguing a matter, it does not really concern any one of us. Neither you, only it concerns your client. And we'll be deciding the issue I'll be deciding the issue with your assistance and with the assistance of Mr. Dey and Mr. Banerjee. So, don't get so involved in this.
I am not involved.
Yes.
Lordship. I'm just reading it.
Yes.
I have to read it.
Yes.
Continue.
Now, Lordship, What is the query of your lordship?
I know query. You wanted to place
Whether
this
it is,
fact.
no, I want
You wanted to
place
place
the
this
facts and
I wanted to
show your
see,
lordship
I
this is not
indicated
a
to you, Mr.
foreign
Chatterjee. I indicated to you, Mr. Chatterjee, one, that you cannot place something which is not there in the record.
I'm reading from the record.
So therefore, you are placing from the records. Place whatever you want to place from the. There is no
I'm not
difficult.
reading anything beyond.
Yes, continue.
So this is their letter. They say the employment of the employees will be treated as continuous and not interrupted by the transfer of ownership, and their terms of employment will not in any way be less favorable than those applicable to employees immediately prior to the transfer of the ownership of the said undertaking.
Yes.
Lordship, let me be very candid. In this, during this procedure, the employees were so unfortunate they were never been intimated about this. Because this is not a sale. They are talking about sale, and why would the sale was conducted? What is the sale? Kindly again read paragraph B of 116. Again, with reference
What
to the
is
transfer.
you want addition of party, Mr.
Yes.
Chatterjee. You want addition of party. You had indicated the grounds on which you seek addition of party.
Yes. I said my specific case is that it is the Ricket
Is
Benkaiser
concluding
followed by the SB Pigments.
Ricket Benkaiser, but their service subsequently was controlled by SB Pigments. That was your case.
And this is the way the service was controlled.
Now,
This is the way service was controlled. How the control was imposed on.
very well.
How the control was imposed on.
Yes.
116, kindly come to this clause once. With reference to the transfer of ownership of the manufacturing unit of ultramarine bulk blue powder business, wherein referred as to undertaking duly notified by the joint notice dated 11th August 2006. It is again being informed to all concerned that ownership stands transferred to SB Pigments Private Limited.
Yes.
Transfer of ownership of the manufacturing unit on slum sale basis. This is the most important, slum sale basis to all assets and liabilities. And with reference to the employees, relevant portion of the joint notice, the employment of all employees will be treated as continuous and not interrupted by the transfer of ownership, and their terms of employment will not in any way be less favorable than those applicable to employees immediately prior to the transfer of ownership of the said undertaking. In this situation, I am asking this question whether my addition of party, my application of addition of party, whereby I wanted to make SB Pigments to have it as a party, Ricket as a party, will that be a question foreign to the entire dispute in this situation? It's not a question whether they are supporting us, whether they are not supporting us. How the dispute would be resolved? It's a question of suspension of the work. When it says that the employment of employees will be treated as continuous and not interrupted by the transfer of
Very
ownership.
well. Anything else, Mr. Banerjee, Mr. Chatterjee, on this?
Yes. Lord, you kindly come to 118.
Yes.
Clause 5. Without prejudice to the aforesaid SBP states as follows. Inasmuch as SBP acquired the business of the Ricket Coleman Company Limited, the employee of the Ricket Coleman Company Limited stood transferred in the name of the SBP. The transfer included all benefits enjoyed by the employees and liabilities borne by the Ricket Coleman Company Limited. These employees stand transferred since 2006. The PF, ESIC, bonus, gratuity, and all other workers' benefits are being given by SBP to these workers. Since August 10,
This is
2000
SBP's case.
SBP's case. This is a case of
SBP.
the Ricket Benkaiser. This is document I'm reading from the Coleman This is show cause
Very well.
SBP's case. 119. SBP submits that the Ricket Coleman Company Limited should be removed from all cause title. SBP states that post 2006 the factory was running smoothly, however, frequent labor unrests and problems compelled the factory to be shut down on 9 September 2009. Several discussions were thereafter held between the management and the workers' union. Ultimately, on 18 November 2009, a memorandum of settlement was executed narrating all the facilities which shall be enjoyed by the workers. The MOS was duly signed by the management, representatives of union, deputy labor commissioners, and additional.
What do you want to add from this? This is their case.
I want to show that this is important. This is not a foreign to the reference. This inclusion. Now, Lordship, kindly come to their order 146. The order include.
Yes.
And how ultimately this order was passed has to be, because this is the order I have received. Lordship, kindly come. Third paragraph, 146. In his show cause filed by the Ricket Coleman of India Limited, now known as Ricket Benkaiser Private Limited, has denied of its being either a necessary party or proper party. It is specifically stated by a business transfer agreement dated 10/8/2006. The factory was sold by the Ricket Coleman to Messrs. SB Pigment Private Limited. The SB Pigment Private Limited, by a letter dated 21/8/2006, informed the union under the order of reference about the transfer of the ownership of the factory to Messrs. SB Pigment Private Limited, and it is Messrs. SB Pigment Private Limited declared the suspension of the work of the factory. The contribution card for currency period of 1/4/2008 to 31/3/2009 under Employees Provident Fund scheme also reveals that the company under order of the reference, namely Messrs. SB Pigment Private Limited, is the owner of the factory in question. So it has been contended that all the documents relied by the Messrs. SB Pigment Private Limited or by the union under order of reference itself reveals that the employer is Messrs. SB Pigment India Limited and Messrs. Ricket Coleman India Limited, now known as Ricket Benkaiser Company. Now, Lordship, kindly come to the last paragraph of this. At the very outset, it may be pertinent to point out under Rule 220D2 of the West Bengal Industrial Dispute Rules of Industrial Court at May, at any stage of the proceeding, add the name of the party who ought to have joined the reference or whose presence is necessary in order to enable the tribunal to adjudicate and settle the question effectually and completely. So the foremost aspect, while considering whether the party to be added as whether the presence is necessary for the proper adjudication of the dispute. Now I read from the third paragraph. In this case, there is no dispute that these workmen under order of reference were initially employed by Messrs. Ricket Coleman, but in the year 2006, by the instrument dated 10/8/2006, Messrs. Ricket Coleman sold the factory to the Messrs. SB Pigments. It was been categorically admitted by SB Pigment in their written statement filed by the proceeding. The copy of the deed has been annexed with show cause filed by Ricket Coleman. Also substantiate the fact that on 10/8/2006, the transfer was effected. This deed has also been relied by the SB Pigments Limited under the order of reference. The copy of the letter dated 21/8/2006, which has been annexed as Annexure C by Messrs. Ricket Coleman with the show cause, indicates that SB Pigment had informed about the transfer to the factory of the SB Pigment was the owner of all concern, including the employees working in the factory. The notice of suspension of work filed in the case is also given by Messrs SB Pigment Limited. So from these documents referred to above, it is evident that Messrs SB Pigment Private Limited was the employer within the meaning of the West Bengal disputes rules and relevant time of the suspensions. The said SB Pigment Private Limited became the employer after becoming the owner by way of purchase of the factory in August 2006. Even the workmen by their petition have contended that the status of Messrs SB Pigment Private Limited was only the contractor under the alleged principal employee, but there is absolutely no document filed before the tribunal by the workmen to substantiate that the status of SB Pigments is nothing but a contractor. It will be appropriate to reproduce some of the recitals of the such and such. Now, Lordship, kindly consider this. The way this has been determined, in my humble submission, this is not
What is wrong in this? Which part?
the part.
Factually, what is wrong? Show me.
Lordship, in view of the page number 118, 119, as well as 112 onwards, these two documents, and the transfer documents which was there between when the transfer was made, this transfer of the particular business units to these SB Pigments. These three documents has to be read together in order to conclude that whether this addition is necessary to make it more effective.
Mr. Chatterjee, you have made out a case that you are employed by SBP, but your principal employer is Wicked Winkers. Any document you have produced in support of that contention, any agreement between Wicked Winkaiser and SBP to demonstrate
Yes.
that?
The document was shown.
Yes. What is that document?
Lordship. Lordship, page 51. This is the agreement. And that's why I want to rely on this. Page 51, relevant portion is 52. Lordship, last clause E.
Yes.
May I read? For the purpose of the sale of the manufacture of the products of the company has agreed to hand over the possession of its office situated at Monok Building, Chowdhury Road, such and such, has been conducting the business relation to acquired business undertaking and relation thereto the inter alia, sale of the products holding, seminars popularizing sale of such and such, provide training to the staffs, vendors, suppliers and agents, market products and buy under the said slump sale. It had been agreed to settle the said business for manufacture of the products and also the purpose of using the office space. This is the sale they're talking about. Lordship, kindly see
Does
the date of the
SBP support your stand?
SBP support.
Show me from the pleadings
Yes.
of the written statement SBP supports. Because in the objection, they have taken a point that SBP does not support that stand.
But in my objection, I'll place that. But we
Very well, very well. I'll put that question to you.
Mr.
So that is all, Mr. Chatterjee?
That is all.
Yes.
And Lordship, let me summarize this.
Yes.
Now,
Yes, summary.
the problem is why this is necessary. The order has to be given by the SBP. And in respect of this, there has been a clause which creates in this particular agreement. I'll show your Lordship, this 61, this non-paid.
So you are saying
non-compete.
that the suspension of work is in effect has been issued by Ricket Kaiser and not by SBP. That you are saying.
Because
the order has to be given by Ricket Kaiser. Is it your case?
My case is that this suspension of work,
That is the issue.
that is the issue. That issue has to be adjudicated, whether it is legally right, justified or not. That has to be tested. For that, Lordship, what are the reasons for that has to be tested. And this particular clause in page 61 kindly come, this non-compete clause, which is there in page 61. I'm just emphasizing on this.
No, that cannot be opened here, reopened here.
But this is important. What is
No,
suspension of work?
very well. Yes, Mr. Banerjee, you are summing up. You
No,
are
Lordship, what I'm not opening it. I'm reading from the documents. I'll conclude it by this.
no, I cannot permit you to enlarge the
reading
scope of
rather-
inquiry to such an extent where you can argue the entire matter here. It's only addition of party application.
Lordship, kindly.
I cannot adjudicate upon while deciding the addition of party. I cannot adjudicate upon any of the issues involved in the proceedings.
That's why, Lordship, this addition of properties.
Yes, let me hear from Mr. Banerjee. Yes, yes.
তবে আজকে কিছু আছে ঠিক আছে আজকে আর কালকে
No, where is your junior?
Yes. No, because I'm supporting the petitioner, I've come to his side.
No.
It's the lighter part of the.
Whichever side you are, Mr. Banerjee, that's not.
Lordship, kindly visualize the importance of this matter. Respondent has become petitioner. And I am solely left out as a petitioner.
I'll make half
as a
arg-
respondent.
Half arguments I'll make from here, half arguments I'll make from there. Your anxiousness raises a suspicion. You see, Mr. De, why are you so anxious in the
I'm
matter?
not anxious, Lordship.
Why you
kindly
want to stall this?
No, I am not. I am not stalling anything, Lordship. Kindly. No, আপনি কোথায় হবেন? ঠিক।
Yes, Mr.
A lot has been argued. Please look at this conspectus from the prism of two questions. 20D2, 1.
Yes.
Second is where a party is dominus litis. And when an application for addition of party, can that be tested by looking at the written statement of the defendant?
That was the petitioner's submission.
That
Petitioner had
That
placed
is
it.
why he was also finding it amusing, and that is where probably the tribunal has also gone wrong. Who is a party necessary? Had the decision has been made by looking at my defense and not by the case that was brought about before the tribunal. This is the jurisdictional error. It's fundamental. Party is dominus litis. I come to court and say I need X to be added for determination of all issues. Your Lordship looks at the written statement in a suit and say, no, I will not add it in a plain.
He cannot go to the merits of the case while deciding. I indicated that.
That's
already.
it.
Because
But
he was taking it too far, so I indicated that.
If the court,
But what is your case? Do you support his stand? A,
have
that
to.
you are a contractor
No,
under.
I don't need to support that. No,
Are you a contractor?
No, my case is
Factually, you are not a contractor under.
no. I can't say that because this agreement today, which is why he was trying to show the agreement. My position apropos this fact is also extremely tricky because your Lordship would have found in the agreement I am called a supplier. So what is the arrangement and why has this happened? He was trying to explain this, and I'll take 20 seconds to explain it. I, as SB Pigman, get into an arrangement with Reckitt. I am the supplier. I have taken over his factory. I have a buyback arrangement with him. So the consideration for this agreement is what I make, he takes. If he doesn't take, and there being a non-compete clause, I don't make. If I don't make, I don't need workers. If I don't need workers, I suspend. End of story. End of story. Now, whether I am now, what did these workers come up with? One more thing, if your lordship will just, I will not go into the facts too much. Little bit I'll have to, because the most fundamental document has not been placed. But before that, kindly have a look at Rule 20D2.
Yes.
Just once, and test my understanding on this. 20D1 and 2, your lordship will just read, and I'll rely on the judgment that your lordship has passed. After the parties have filed their statements, the Industrial Tribunal Labour Court may fix a date for framing, if necessary, issues relating to and arising out of the points or points in dispute as referred, and matters incidental thereto, as well as additional or subsidiary issues, not enlarging in any way the scope of the points referred to for adjudication on the merits, nor adding to their number, but required for dealing with extrinsic contention, intrinsic not. Not the word in the legislation is not intrinsic. Extrinsic contentions raised by the parties about the reference and its hearing. Why extrinsic? Like your lordship has held in the judgment which is on, because there are matters incidental, allied matters. So what is extrinsic also is to be looked into. When the legislature has before it 20D1, permitting a tribunal to look at extrinsic issues also, this is a very important word, does not say intrinsic. Then it drafts 20D2. And one word I'll harp on here. The Industrial Tribunal Labour Court may in any stage of the proceeding, either upon or without the application of any party, and on such terms as may appear to the Industrial Tribunal or Court, just order that the name, please mark this, the name of any party who ought to have been joined in the reference, kindly mark or whose presence before the tribunal may be necessary in order to enable the tribunal or the court to effectually and completely to adjudicate upon and settle all questions involved in the dispute be brought on record. So two-pronged power or necessity-based jurisdiction. This or is very significant, and it's not and. The name of the party who ought to have been joined in the reference. And 20D2 is after 20D1. And 20D1 opening words are after the parties have filed their statements. Because it's possible that not just from my, if I call it a plaint, from the written statement also a case comes out by some other party in their city. It's possible. But in this case, your lordship need not go into that aspect. After filing of the statement, with the plaint on board, could or ought the tribunal have to look at 20D2 from these two aspects. Somebody ought to have been joined. So not necessary that I have to go and make an amendment. The tribunal could have done that. Or somebody whose presence is required for complete and effective resolution of all disputes, which may be incidental and extrinsic to the main issue. Now, the issue before the tribunal is what? I'm not on the point of reference, because your lordship would have found the contention is what is the jurisdictional fact. At 20D1, nor adding to the number, but required for dealing with extrinsic contentions raised by the parties about the reference. So an impression is given that the reference is what? So with regard to the reference, the contentions that are raised even if they are extrinsic, the tribunal has the power to determine those. So what is before the tribunal after filing of the statement is what? So the jurisdictional fact is his jurisdiction is the reference. His jurisdictional fact is the contentions that are raised before him apropos the reference. Can he go beyond the reference? No. But can he look at these extrinsic? There is a reason why the legislation very consciously has used the word extrinsic contentions. Otherwise, it would have no meaning. So the power is given to a tribunal to look at these contentions in aid of resolution of the points of reference. Because not necessary under industrial law that the government will have to identify everything. The points of reference need not be referred, need not be specified. Section 10 doesn't mandate it. You may or may not. So when points are mentioned, extrinsic contentions to that point, the juris power is there.
Come to
Then
section 10 once.
yes.
Yes.
Look, 10.1, may I? Where the appropriate government is of the opinion that any industrial disputes exists or is apprehended, it may at any time, by order in writing, refer the dispute to a board for promoting settlement, refer any matter appearing to be connected with or relevant to the dispute to a court for inquiry, refer the dispute or any matter appearing to be connected with or relevant to the dispute if it relates to any matter specified in second schedule to a labor court for adjudication, refer the dispute or any matter appearing to be connected with or relevant to the dispute whether it relates to any matter specified in second or third schedule. Then there is a proviso. This your lordship will find, my lord.
What is the dispute? The dispute is captioned at the top.
Caption at the top.
And issues are framed subsequently. The issues may vary. These issues may be enlarged, but the dispute cannot be enlarged. Dispute, that is the question. That is what I initially pointed out to Mr. Chatterjee. The dispute is identified in the first paragraph of the order. Mr. Banerjee, kindly come
74.
No,
sorry. No, not 74.
Yes, I want an answer on it.
76.
Yes. You see that this is the dispute. Now, Mr. Chatterjee's answer was somewhat different. Mr. Chatterjee says Ricket Benkaiser is there. Now, Ricket Benkaiser is the workman really. They are the representing the workmen. So, what is the dispute? The dispute is between two entities. And these are the issues. Issues may be enlarged.
Forgives me.
No, I'm trying to, yes. Yes.
Forgives me. But
Yes.
a fabulous query comes back to 10.1.
Yes. That is why I wanted to see this.
Comes back to 10.1.
Yes.
The industrial dispute is not referred to in 10. I mean, is not defined in 10.
No, it has been defined otherwise in the act itself.
So what is an industrial dispute is referred.
Yes.
When the government apprehends that there is such
Very well. Come
such
back
an
to the industrial dispute, Mr. Banerjee.
Yes,
What is an industrial dispute? It is very important.
Section 2K.
Yes. So that will ultimately I have to consider that aspect also. In the other judgment, I had taken into consideration that.
Yes, your lordship has.
Yes. So
And the other judgment I'll rely on.
Yes. So come to 2K.
K
Yes.
just give me a minute. Means any dispute or difference between employer and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment please mark the next word, it will be relevant for this matter. Or the terms of employment, or with the conditions of labor of any person. So terms, conditions. Now, this is an industrial dispute. Well, this is why your lordship wanted to have the records called for. When I was
Is there any
arguing,
scope? Is there any scope to include within the scope and ambit of an industrial dispute, within the meaning of Industrial Disputes Act 1947, the principal employer and the workman?
no, here, my lord, what has happened?
That is another interesting aspect which you have to take into consideration.
May
Because
not for maybe some other matter. For this one, I'll shorten it for your lordship. From my understanding, test it. Kindly come back to reference at 76.
yes.
Whether so there is a dispute which is identified. The reference is 1 and 2. So the tribunal is being told that this is what you look into.
And this is the issue. You can enlarge this issue.
You can
Ancillary issues, whatever comes out
you
of it,
can, yes.
out of first paragraph, whatever is there in the first paragraph, nothing beyond that.
So when I'm looking at whether the suspension of workers declared by the management of SB Pigments Private Limited from 4/11/2011 is justified, now please have a look at the plaint. I'll just call it that. They've called it written.
Very well,
finding it
no
difficult to call it
difficulty.
written statement. Kindly have a look
I
at
had also a lot of difficulty to understand two written statements were being filed.
we find it
Yes,
very
yes.
difficult. So page 81, your lordship will just
Yes.
have a look at. Disregards the party,
Learning process, Mr. Banerjee.
but this isn't. Well, it's a query that makes the bar.
No, unless I get to know from you, the difficulties, if I decide this matter without getting your response, then
it's
it
a
will be,
futile. It's a
yes, it will futile exercise. The entire
Absolute-
exercise will be futile.
absolute. Not about winning a matter or losing a
No,
matter.
no,
It
no.
must advance.
Yes, absolutely.
80 onwards, kindly have a look at. Disregards the parties.
No,
Let
it's
us
all-
say that even Beckett is not
Yes,
not there, I am
yes,
not there.
Yes.
What is the plaint before? Lord, 80 starts and then turns over to 5. That the union respectfully submits on behalf of the workmen who were initially directly employed by Reckitt Coleman Company, but subsequently the said company was named as Reckitt Beckinsale, having his office at so and so as per schedule annexed herewith. This written statement, the service of the workmen were out and out utilized by the principal employer, which is known as Reckitt, as an admitted position on record, ventilated in the Provident Fund Code, ESIC code number, all are unchallengeable position on record. That the above named contractor, which is me now, SB Pigments, certainly operative position by virtue of an agreement so conferred by principal employer to the contractor, so reflected in the name of the contractor in the order of reference sent for adjudication. When specifically the contract and conditions of employment, please mark this paragraph now. When specifically the contract and conditions of employment as pre-existed with the principal employer from the very inception of tenure of employment in accordance with the contract and conditions was remaining in unaltered position even till the date duly affirmed and signed either of the parties and unconditionally wherein the rights and privileges not to be arrogated either of the principal employer or by the indemnifier. I'll show to you lordship why I'm being called an indemnifier. The union respectfully submits before this learned tribunal the name of the contractor under reference, Pigments, who was a coordinator so entrusted by the principal employer above named, with effect from 10/8/2006 to be taken service from the workman applicants for the interest and benefit of Reckitt Beckinsale Limited, and service of employees so ventilated in, then 8. The union begs to submit that a deed of indemnity is executed on 8th August 2006 by SB Pigments, having is registered as the indemnifier, and such indemnification had in its favor Reckitt Beckinsale, an existing company, then so and so again. turns over, my lord, after the parties are identified, hereinafter referred to as the indemnified in terms of the business purchase agreement. The indemnifier has indemnified inter alia in respect to exercise duly relating to all the matters when the contract and conditions of the employee wherein the employment role to be in pre-existing position among the parties without any alteration. Let us just stop here for a moment. This is about suspension justification. Alteration in conditions of service or terms of employment is an industrial dispute. An impression is being given and has been taken by the tribunal that I am trying to settle a principal employer-employee relationship, principal employer contractor me relationship through this reference. That is not the case at all. The case with which the parties had gone to upfront, this is not the addition of party, this is the plaint, is I had, just give me 20 seconds,
Yes,
that as workers, I had an existing condition of service with X. Call it a principal employer, call it Johnny, call him anything. This X gets into an agreement with Y. Y thereafter starts hiring me. Y has declared suspension, whereas my relationship or conditions of employment are with X. Y could not have suspended us when I had an unaltered position of employment with X. And this will come from the next two paragraphs.
I'm with you on this, but difficulty for this court is, Mr. Banerjee, if this was the case,
this is the case.
Yeah.
This is the plaint.
Now, if this is the case, then the reference did not support this absolutely.
Well, the word justified is what I'm saying, that it's not justified because you could not have altered my conditions of employment when my conditions of employment were with X. Therefore, suspension by you is not justified. And I don't say it off the cuff. Please have a look at those 9 and 10. The cause of action is paragraph 9. Kindly have a look at paragraph 9.1. This is not a principal employer contractor employee relationship dispute at all. That's what it was, a mistaken understanding of the tribunal. Your Lordship asked my learned friend, where has the tribunal gone wrong? It's gone wrong here. Paragraph 9 was before the tribunal. That the union begs to submit that a tripartite memorandum of settlement was initiated and was settled by and between parties on 21/7/1999. And the said agreement was perpetuated in pursuance of Mrs. Monisha Bhattacharya, Assistant Labour Commissioner, Government of West Bengal, Asansol. And this memorandum of settlement was signed by the authorized representative of Reckitt Beckinsale and was signed by the representative of the union.
So there is a breach of this settlement.
10. Union submits with an ulterior motive the company notified suspension of work by violating. So 9 is my right, 10 is my cause of action.
9 is your right, which has been breached.
Which has been breached by
10.
That's right.
Now, why do you not seek for reference of this particular dispute?
Well, I don't, because when we draft a plaint.
No, not you. Not you.
I understand the query. Well, this is troubling the court. It troubled me too. When I draft a plaint, would I make a declaratory prayer in respect of paragraph 9?
Had it been a civil cause?
No.
For the asking, Mr. Banerjee.
That's the difference.
I
am not going to argue.
The case that has been made out up to now for the asking would have been added. But difficulty is that
the tests are
powers are, the test is different and the power is limited. Notwithstanding the wording contained in 20D2.
Yes.
Still then it is limited.
Without a doubt.
Yes.
Well, I will not argue what I know is not the law to win a matter.
No, that's it.
But what I understand to be the law, I will at least address your Lordship on that and your Lordship will test me on it. Here, well, now apropos your Lordship's query, why didn't I make paragraph 9 a reference? Well, if I was to draft a suit, I'll just give an example. Would I have sought a declaratory prayer in respect of paragraph 9 and diluting that right under it? Or would I treat paragraph 9 as my right and then show that the breach was in violation of paragraph 9. Why would I put my own right in jeopardy by seeking a declaration on it? There is no dispute existing whether this settlement is binding on the parties or not.
Then for that purpose, you do not need Ricket Kaiser.
Then that's why I need them. And I'll tell you, Lordship, why. Because these are matters that when the tribunal is deciding whether the suspension is justified or not, these are at least I'm saying, in my understanding, these would be intrinsic contentions, but at least would be extrinsic contentions. This paragraph 9 is why Reckitt is running away from the proceeding. It is because of this. There is a reason why Reckitt also is resisting this application. And is resisting is because of paragraph 9. But do I really need a court to look into this or these aspects at an addition of party? And your Lordship has rightly pointed out that no. Merits you don't need to see. I am not showing your Lordship the application for addition of party. I am showing to your Lordship what my cause of action was with which I went to show that the suspension is not justified. Why is it not justified? Because I have an agreement which identifies what my terms of conditions of employment are, what my terms of service are. In breach of that, you've gone ahead and you've suspended me. Now, I will need Reckitt on board to establish paragraph 9. I don't need a dispute on it because no one's disputed it. This paragraph 9 settlement, there is no dispute with regard to that. Is the substratum of my right. That I don't want to make a dispute over. It's only when a dispute exists apropos the settlement could I have gone under 10 to seek a reference of the dispute. This is not a dispute. In fact, my case is that when paragraph 9 is there, a tripartite settlement is there which decides my conditions of employment, how could you, on the strength of this agreement, come and suspend me? That is my case. That I have paragraph 9 settlement with me. You get into a buyback agreement with my principal employer. Let's not call him that. That is causing confusion. Let us say that this Reckitt Beckinser, Ben Kaiser.
So to establish that the suspension was not justified, you need to establish that there was a settlement that took place on 21st July 1999. And for that purpose,
two additional things I
need
Reckitt for two more things. One is to complete the cycle with regard to that buyback agreement. Because it is by dint of that buyback agreement where there is a buyback clause, there is a non-compete clause, and these are matters that these are not even incidental. This is the heart of the issue. This entire dispute has become whether I'm trying to solve, and your Lordship will find that consideration in the tribunal's order. Whether I'm trying to solve a principal employer-employee contractor relationship here, that's not the case. My case is, as your Lordship rightly saw in 2K, conditions of employment, and its justification is the issue. Whether my suspension is justified. I'm saying it's not justified because of X and Y reasons. I have an agreement with X, which is binding on them under Section 18 of the Industrial Disputes Act. Because it's a settlement agreement, it makes it binding on the parties. You are a supplier of that person who's named in the agreement. But if the tribunal has returned a finding that this is not a principal employer-employee relationship dispute, then whether I call SB Pigments a contractor, whether I call SB Pigments an employer, that pales into insignificance. Suspension has been ordered by SB Pigments. I am saying SB Pigments could not have ordered the suspension because I have a binding agreement under Section 18 which protects my conditions of service with my employer. SB Pigments has a buyback arrangement by dint of an agreement with my employer. The management of SB Pigments could not have thrown me out. Whether SB Pigments is my owner, is my employer, not return a finding. Extrinsic, but not relevant. Whether Reckitt is my employer, finding not required. Your Lordship will record. Whether Reckitt is my employer, or whether SB Pigments is my employer, it's completely irrelevant, beyond the scope of reference. But whether this justified suspension or not, in ascertaining what the justification, is this at least an issue or not? And then, sorry, Manoj.
Yes.
So would I need this party to be on board to push forth my right that stems by an agreement with this party? So that why is Reckitt now running away? Because if he joins, he has to give a rejoinder or written statement to this. He will have to deal with paragraph 9. With regard to paragraph 9, then Reckitt will have to take a stand that with paragraph 9, a binding settlement there, whether by this and this is one of the most important, with this settlement there, whether Reckitt by way of a buyback agreement could have allowed SB Pigments the right to suspend me. If that answer is a no, the justification to suspension is a no. It's the end of the reference for the workers. These two issues will come because they will have to give a rejoinder to this. And this is under Section 18, your Lordships are aware, these settlements are binding. So with this settlement binding, I can put that person in the dock and have his affirmed stand on board. Could he have entered into this arrangement, giving rights to SB Pigments to suspend me also, to change my conditions of contract, of employment? With the first part snapped, I will, as workers, never be able to bring home the justification charge. Well, then what will be left with me as workers would be just violation of procedure. Suspension notice not given. This is the core issue.
Yes.
This is the core issue. Because if I can show, then all other technical points of no notice, no suspension, all that will become irrelevant for me to bring home this charge.
Very good.
Now, with regard to one thing, where the jurisdictional tribunal has gone wrong, in my respectful submission, is he has not even considered this.
Place reliance on the objections put forward by the respondents. And
So he's
on
looked
the
at a
merits of
written
the
statement
case.
to a plaintiff and decided what?
Yes, on the merits of the case to decide whether the person should be arrested.
That's right. That is the jurisdictional error. Also, if I may just add, for your Lordship's kind consideration, that when he does that, he's gone on to determine or frame an issue which is not, which records it that his issue does not have to be answered. Who is the principal employer of the workman on the basis of the cause title, what they've gone and told? Not required. But this can't be taken away from these workers, because this is my defense too. Why is SB Pigments today arguing with the workers? And why have I therefore become the other side of Reckitt? is this is my defense too when I file my written objection. Not so much in the written statement. In the written statement, I've gone and said, no, no, these are my workers. But that doesn't change the position. My case is which might actually become extrinsic. My case is extrinsic to the issue. I've said there was a buyback arrangement. They did not honor this.
But this has not come from the petition.
They should have shown this, but I am not showing my document.
Very well. No, no, it's
He should have argued this.
very well.
That,
Anyway,
but I am showing
I
their
will have
document.
record. I'll also consider it as a submission made.
And in your lordship's order, Lord, which is referred to, which my learned friend will refer to, this analysis is complete. Paragraph, I'll place it. Paragraph 20 onwards of that judgment, this analysis, in fact, Lord, this what I argued. I understood it from your lordship's judgment, paragraph 20 onwards. And once your lordship reads it, your lordship will understand that I basically read out your lordship's order. This is my lord's judgment of Messrs. Tata Chemicals Limited. I got the copy.
My copy is there.
Well, this is where, and the distinguishing feature, I'll just indicate paragraph 5. And then I'll come to the understanding of the law that I understood the law to be. Paragraph 5. Notwithstanding the petitioner not having any direct contractual relationship with the respondent number 3, the petitioner was served with a notice dated 22nd November 2016. So here, Lord, if I may just pause, what had happened was X used to hire persons who would go and do the job. So X hired B, B hired A. Difference happened between A and B. Gets referred. In this industrial dispute between A and B, X is put on notice, X is added as a party, X comes before your lordship that because of paragraph 5, I have never had any contractual relationship, I am a nobody. There the issue was whether suspension, this was justified or not. There was no contractual relationship at all. So your lordship rightly returned a finding that this is not even connected with the dispute. But the biggest distinguishing feature here is paragraph 5 of your lordship's judgment and paragraph 9 of the plaint that is in this matter.
Paragraph
9 of the
Yes,
plaint
9
in
and
the
10.
matter.
9 and 10.
9 and 10.
Yes.
Here the case was there is no contractual relationship at all. Here the case is in this matter that your lordship is hearing today, the case is founded on the existing relationship with Reckitt or Beckett. Reckitt. Now, my lord, apropos the law, kindly have a look at 17 onwards. May I, my lord? First 6 line, and your lordship will understand on from what basis I argued today. This is what I read and learned, and then I came and spoke English. Test.
Yes.
One line I'll read from your lordship's paragraph 22. It is thus always a must that the addition of party is necessary to make the adjudication itself effective and enforceable. Please test this litigation, this matter, on this one line from your Lordship's order at paragraph 22. With paragraph 9 and 10 from the plaint, and this one line from paragraph 22, because this really sets out the law on addition of party, this judgment, and how it's different from the civil procedure code angle. But as your Lordship discusses the limitation, but also highlights the ambit of that power of 20D2, specifically recording in 20 that issues that are a contention that are extrinsic. So in aid of that, if I need someone to decide this issue, and I don't think that I need to really bring my case that low down to say this is an extrinsic issue. This is the core issue involved, except that the wrong end of the rainbow has been caught by the tribunal. He's caught the end where he thinks he has to decide a principal employer-employee relationship dispute. The right end of the rainbow is just matters connected with my employment that could not have been changed.
Yes.
Well, these are my respects.
Yes. Mr. De.
Could I also take a 5-minute break?
Yes, sir.
I'm sorry that your Lordship can't.
No, you see, I'm accustomed to sitting the entire period, excepting for on certain occasions I do rise, but for a different issue. Absolutely, because here you get accustomed. After a while, you get accustomed sitting. Yes. 2 hours, 2 to 3 hours max. Not even 3 hours. 10:30 to 1:15. Not much.
I may just take a 2.
Yes, Mr. De. Assuming the tribunal had passed a wrong order in the facts. Answer what Mr. Banerjee submitted.
Yes, I will start from there.
Paragraphs 9 and 10.
Yes, I will start from there.
How do you justify this portion?
Yes,
Only to that extent. And assuming whatever has been stated in the petition may not be correct.
Just you kindly take the trouble, because I think
You answer on Rule 20D1 and Rule 20D2.
prior to that, I will beseech your Lordship to consider section 25FF.
Because this is not really a case of principal employer and a contractor. Not a case of principal employer. Although they may have spelled out the same in their application.
So kindly consider
Yes.
25FF.
Yes.
If I read this thing, Lordship,
20?
5FF.
Yes.
This is my statutory right to sell the property recognized by the Industrial Disputes Act, apropos the relationship of the employer-employee between the proposed buyer and the vendor, where the ownership or management of an undertaking is transfer. Undertaking means factory. Whether by agreement or by operation of law from the employer in relation to or that undertaking to a new employer. SB is a new employer. SBP. Every workman who has been in the continuous service for not less than 1 year in that undertaking immediately before such transfer shall be entitled to a notice of compensation in accordance with the provisions of section 25F as if they would have been retrenched. So first part of the definition shows I have got the statutory right to sell out my undertaking, my property.
And this is you have to comply.
And the relationship of the employer-employee relationship between the vendor and the erstwhile owner and the employee will be snapped. My responsibility is to pay only retrenchment compensation under section 25F. Now, their right has been protected. Then provides the comes. Provided that nothing in this section shall apply to a workman in any case where there has been a change of employers by reason of the transfer if here the transfer of ownership is there, apropos employer is there. The new employer will be the owner. The service of the workman has not been interrupted by such transfer. That condition has been fulfilled. Continuous. Page 41, I will show before your lordship. The terms and conditions of service applicable to the workman after such transfer are not in any way less favorable to the workman than those applicable to him immediately before the transfer, and the new employer is under the terms of such transfer or otherwise legally liable to pay to the workman in the event of his retrenchment compensation on the basis of his service has been continuous and has not been interrupted by such transfer. Then three contingencies are there. First speaks about there will be severance of employer-employee relationship. The erstwhile owner is to pay the retrenchment compensation. This is the first one. Second one, if their right of the workman has been protected, how? There will be continuity in service and they should not be transferred to an establishment or new incumbent with the terms and conditions which is less favorable. And then if the workmen do not want to join the new employer simply issue him the retrenchment compensation, nothing else. Now, Lordship, kindly take the trouble to 41 of the writ application. And the fate of the entire.
Why new employer?
Huh?
It is the old
The old employer. Old employer just pay the retrenchment compensation,
Yes,
nothing.
not the new.
The new employer. Old employer, considering the continuity of the service, nothing else. So you go, your right is protected.
Dispute, if at all, was between you and these persons.
Now let's kindly consider page 41. Page 41 of the writ application. So once I transfer the ownership to a new entity, and once
Let me understand, Mr. Day. So you are trying to say that dispute, if at all, what is being alleged, the case is sought to be made out today, was between you?
Not between me. Between workmen, union, and the new employer.
No. You are saying, Mr. Day, that 25FF speaks of certain eventualities, which confers a right on you to transfer the undertaking.
Yes.
A. Which also enables the workmen to get compensation. B.
If they do not want to join the new employer.
Correct, enables.
Yes.
The enabling provision
Enabling provision.
gives a right to the workmen to get this compensation, right to you to transfer, right to the workmen to get the benefit in the form of compensation if they do not want to continue. So if dispute, if at all, was limited between you and the workman, which is a substantial dispute
At the time of transfer of
at any
undertaking.
stage.
No,
Naturally, at the time of transfer.
transfer, yes.
Correct.
So once it is transferred,
And that is a substantial dispute.
yes, that is a substantial dispute regarding transfer of undertaking.
There was no dispute raised.
There was no dispute raised. Why I am troubling your lordship? Because I will place the order of reference, nothing else. So once the workmen as a whole joined the new incumbent, and there is no allegation that they were asked to join with less favorable terms, I do not come within the picture. There never subsisted an employer-employee relationship between myself and the workmen. It is snap. In industrial law, there is no concept of inheritance. It is either existence or non-existence. The lease never subsides once I transfer, and once the workmen go to the new employer. Lordship, kindly take the trouble to page 41. Page 41. Page 41, Lordship. Kindly take the trouble. The new employer issues this letter to the union before your lordship. The new employer, SB. Dear sir, with reference to the transfer of ownership of manufacturing unit of Ultra such and such, duly notified by the joint notice dated such and such, it is again being informed to all concerned that the ownership stands transferred to SB Pigmentation Private Limited on the terms such and such. The relevant portion of the joint notice is being appended below. The employment of all employees will be treated as continuous. That is the proviso 1, 25 FF proviso 1, and not interrupted by the transfer of ownership, and their terms and conditions, terms of employment will not anyway be less favorable than those applicable to the employees immediately prior to the transfer of the ownership. That is proviso 2. They were happy with it. My lease with the factory employees got severed statutorily. It is severed statutorily. Section 25 FF. Now, Lordship, kindly consider, your Lordship was looking into section 25, section 2K, industrial disputes. Let me put in my humble way. Section 22K, Lordship.
No, 2K is different.
No, Lordship, why I'm on?
It is
Why?
related to industrial dispute between the employer and the employer and the workman. It is identified, whosoever be there.
So,
Not between the principal. That is very
no, I am not on principle. I am not on
But
that.
their case is also not on principle.
No, I am not on that, Lordship. I am on the two terms.
But I will ascertain from Mr. Chatterjee, because that is contrary to that is not really there in the petition. That I have to ascertain from Mr.
Chatterjee. That's why in my humble
Wait,
way, before going into the facts, I am trying to canvas before.
No, just 1 minute. I'll ascertain from Mr. Chatterjee. Mr. Chatterjee, you are not insisting for any principal-employee relationship. No, I will record that. No, this is contrary to your petition. No, you have to give, then I will record that you give up. But can you give up this? No, can you give up this case?
Then nothing remains. Then WS goes.
No. Whether he can do this, whether this concession can be given by an advocate in course of hearing
Yes.
without an affidavit.
Lordship, what is there?
Then you put in an affidavit to that effect. No, difficulty is Mr. Chatterjee. I've also heard, I've recorded what submissions have been made by Mr. Banerjee. I have recorded them. Now, Mr. Banerjee's argument proceeds on the premise of paragraphs 9 and 10. Very categorical. Just a minute. So, therefore, today, I accept that contention, so far as you are concerned. But you have to say that. Yes?
Yes, Lordship, that
And you do not
aligns.
say that Ricket was a principal employee.
It's a continuation. That is the thing.
No, that was not the argument what Mr. Banerjee advanced.
My argument, Lordship, here, it's
Very well. I don't know. You are entitled to retain that. Then I will proceed on the premise that whatever is there in the petition, your petition stands.
Lordship, I want to give it up. This
No,
particular
you
this
cannot. You
proceeding,
cannot. No concession can be
for
given
the
by an advocate in
purpose of
court.
this proceeding, I cannot take up this. as
No,
a-
no, the advocate cannot, and especially in these worker matters, you should not, Mr. Chatterjee. Whatever is there is there. Very well, very well.
Now, Lordship, what I am addressing,
No, I won't, because your submissions I've recorded. Now, it's a little conflict. There is some conflict between your submissions and Mr. Chatterjee's submission. Now, I wanted to ascertain from then I thought, no, he cannot give this concession also. These are labor matters. No, he cannot. And a concession on law, concession on law is one thing. Fact is becoming a concession on fact. He cannot give that. No, but that point is there in the petition. That point is there in the petition. I have to ignore that, Mr. Chatterjee. Mr. Banerjee, I have to just wait. I have to ignore that because your arguments are on a different plane. Absolutely, absolutely, and I have recorded that.
No, Lordship, kindly come.
Just a minute. Difficulty is what you have argued that does not fit in with paragraph 1 of the petition. One of his petition. Addition of. Correct. You are absolutely. You are showing the plane. Now, in the plane, paragraphs 9 and 10, you have clearly identified what is the right and what is the reach.
That is the foundation, Lordship.
Now, the petition remains. The petition still remains, including some other paragraphs in the written statement also.
In the plain, I just call it that the best.
Plain, very well, in the
In
essay.
the plain, there is no requirement of the tribunal to decide who the principal employee. That is not it.
But how can I ignore his case? Then he has to.
It's
Yes.
not there, Lordship.
No.
I will come to
Page number, I'll just tell you. Page number 107.
Lordship, I'll show from this.
No, this issue needs to be clarified.
In his plain.
It is not true.
Come to page number 107.
Written in his application for addition of party,
This case is different.
kindly have a look at.
I will ignore his case provided he ignores that. Otherwise, I cannot ignore this.
No,
How can I?
but by an addition of party, he really can't enlarge what his plaint is. His
Correct. But in the plaint also
He
this is
doesn't-
there.
plaint, you also have a look.
Yes. Come to this plaint. Page number. You were placing
77 it starts.
77. Yes.
Lordship, kindly come from 70 and 80.
No, Mr. Chatterjee placed it initially.
The above mentioned opposite party company is a company, and Lordship, kindly come to 81. The applicant's workmen and been working more than 25 years and little more less.
Paragraph number 5.
85 onwards.
Five,
Indian
six.
submits behalf of the workman.
5,
initially
6, it is
directly
there.
employed.
All that is there. So
Initially
he-
directly
so
employed.
He doesn't.
So
the
it becomes
workers-
incongruous to one extent.
No, the
Lordship,
workers
these are the facts.
The workers don't require an adjudication on this issue. These are facts which are leading up to page 89. Can you have a look at 89? Then it's.
No, I have to consider this. also.
Of course, but this is not the worker's case. That please decide who my
It is
principal
there, it-
employer is. No, that's the narration of why he's saying the suspension is not justified. That I was employed under Reckitt. Reckitt has an agreement with me. Now, by way of a buyback, have a look at page 89, my lord. They've summed it up. They've summed it up, page 89.
Very well. I
They-
cannot
they
ignore
got-
this paragraph 5 also. Very well. Very well.
The
Very-
5 to 10 or 11 is the narration of facts where they show why suspension is not justified. If your lordship looks at 89, paragraph 22 onwards, and then his prayers at page 90, completely within the scope of the reference,
Very well.
and doesn't seek adjudication on who my principal employer is. There are no prayers with regard to that. Nothing. At 89, if your lordship has a look at 22, the issues are identified of the reference. 22 issues are identified. Then 22, union on behalf of petitioner employer workman beg to submit that under the purported termination by way of a suspension of work and refusal of employment, their services under the veil of cessation of work by the opposite party company did not observe the statutory preconditions. The suspension of work, purported termination of service under the veil of cessation of employment by declaring suspension of work of your employee is therefore void, ab initio, irregular, illegal, for which the applicant's worker is entitled to reinstatement with full back wages. Then his prayers are at page 90. So he does not require a fine. This is where the tribunal has gone wrong.
Very well.
On the understanding that he'll have to decide who's the principal employer is not required. 5 onwards is just a narration of fact as to why the suspension is not justified. Because I was employed by X, I have a binding settlement under 18 with X, X has entered into a buyback agreement with Y, Y has gone ahead and suspended me, Y could not have suspended me when I have this with X. That is the case, long and short of it. Now we try to
Yes.
implead X. There are no prayers.
Yes, Mr.
So
Conclude.
I have submitted before your lordship section 25
Yes.
when X has sold the property to Y,
Page 41 you have also indicated.
the relationship and the lease between the workman and the X goes in the wind. First. Secondly, section para 40, page 41, the new company, Y mark new company has given letter, I am your employer. ID definition, why I am beseeching your lordship section 2K of the Industrial Disputes Act. 2 words are very vital. One is employer, another is workman or workman. Employer definition your lordship will find
Both are defined.
lordship.
Both are defined.
Yes, both are defined. To G. Roman 1, I am not coming. Then in Roman 2, 2G, Roman 2. In relation to an industry carried on or by on behalf of the local authority, the chief executive officer of the authority. So it is being run by now Y. X is nowhere in the picture. Once proviso to section 25 FF are complied with. Why the word employer or employed are vital? Your lordship will find from section 2A the definition of workman. Any person employed, this is the determining factor. And that's why the tribunal did not go wrong in deciding SB pigmentation to be an employer. Industrial dispute exists between workmen and employer. Nobody else. Under Industrial Disputes Act, concept of principal employer is nowhere there. That is under Contract Labor Regulation Abolition Act 1970.
That is all.
No, I have to. Certain things are Now, shall I continue in the next?
No, you complete.
Yes. Then Lordship kindly consider section 2S employed.
Yes.
Now Lordship kindly consider section 10. Prior to
Section 10,
that
Mr.
section,
Manager has shown me.
huh?
Scope of section 10, Mr. Manager has indicated.
Kindly Lordship kindly come to section 12. Power of the conciliation officer. In industrial dispute, 1940 Industrial Disputes Act 1947 is only speaks about industrial dispute, which has been defined under section 2K, nothing else.
Section 12.
12, Lordship kindly consider the power of the conciliation officer.
Yes.
The very first word, duties of the conciliation officer. Where any industrial dispute exists or apprehended. So existence of an industrial dispute or apprehension of existence of an industrial dispute is centers around really between the employer and employee. After section 25 FF, I goes from the picture.
That point you have
Proviso,
made. That point you have made. It is already there.
yes, that's why, Lordship. Now, conciliation officer. During the entire conciliation, why I am troubling your Lordship? Because my learned friend has shown para 9 and para 10. I will take you to Lordship to
You
that
did not
effect.
answer that.
I will. This is the prelude of the entire thing. Then I will go to section para 9 and para 10. So far as para 9 is concerned, whatever liability continuity, whatever is there, that goes to Y, the new incumbent. SB pigmentation. Statutorily, my relation with the company is snapped under section 25 FF. I cannot be bound under Industrial Disputes Act. This is not a civil suit. This is not a case of non-compliance of the agreement.
The previous agreement does not evaporate. Settlement does not evaporate.
That's why the next paragraph.
What is your answer? What is your answer, Mr. Dey, to the question that whether you are required for the purpose of proving that particular agreement or not?
Not required, because issue is suspension of 2011. Lordship kindly consider. Issue.
Yes.
Page 74. Page 74. Page 76. First, whereas an industrial dispute exists between SB Pigmentation Pigments Private Limited and the workmen represented by such and such. So there should be an existence of industrial dispute. Government has formed an opinion that existence of employer-employee industrial disputes exist between X and Y.
Correct.
I
There is
am
no
over to
dispute with regard to this, that
Then-
existence
then
of the
issue,
dispute.
then
Then issue.
issue. Where the suspension was declared by SB Pigmentation dated 4/11/2011 is justified.
Yes.
Is justified. The date is 4/11/2011.
Yes.
I am nowhere in the picture.
Correct. Because your relationship has snapped. There is no difficulty in
Now
understanding
section-
that.
Yes, section para 10 of the written statement, what my learned friend has placed, that speaks about there was earlier suspension of work in 2009. Your Lordship is not going to adjudicate the suspension of work of 2009. Then 2009 there is a settlement, again tripartite settlement, that never takes away the right or never brings into the picture Rekit Coleman. Lordship kindly take the trouble. My learned friend has placed this thing beyond his own written statement, 94 to 97, where he has said that yes, I am the employer. Beyond that, my learned friend can go. He has taken the brief of the petitioner being a respondent, And he has tried to canvass before your
He
lordship.
is assisting the court, Mr. Dev.
Absolutely,
You also-
lordship. I am also assisting your
Yes,
lordship
yes. So
because he cannot go. No. When he is taking up his own brief,
yes.
he cannot forget his own stand before the tribunal. 94,
Yes,
he is
very
an
well.
employer.
I have
So-
got it. Yes.
So if I am not an employer, no relationship exists between me. I cannot be brought into the picture because section because rule 20D. I will take your lordship. Prior to that, lordship,
Come to rule 20.
lordship. Prior to that, lordship, kindly consider the voluminous documents which we have submitted. It is the certified copy which was there before the tribunal.
Yes.
That will clarify the entire thing.
You will not conclude today.
Yes, certainly.
No, second half. Very well.
Lordship, kindly
There are
give me
another
10
set
minutes.
of matters.
Lordship, kindly give me 5. Kindly give me 10 minutes. Nothing.
Yes.
I will conclude it. Lordship, kindly consider. This is paginated. Page 74.
Page
74.
This is the 2009 settlement.
Yes.
74 suspension.
Why I am troubling your lordship, kindly consider page 84 of the written statement of the union. It has got a reference of 2009 suspension of work declared by HB pigmentation. It is not that after 1999 settlement, it continues, there was no break and no tripartite settlement. Lordship, kindly consider page 84, the written statement of what they have relied on, para 10. The union submits that with an ulterior motive, the company notified suspension of work on 8/9/2009.
Means the statement of claim.
Yes, it is
Yeah, even.
complaint, whatever.
Yes.
Page 84. Because they have concentrated on 9 and 10. I am taking to your lordship, troubling your lordship on 9 and 10, nothing else.
Yes.
Suspension of work on 8/9/2009 by way of violating all statutory entitlement was not paid to the workman by way of contaminating the precondition and prerequisites of legislation. This is the thing. So prior to that, thereafter there was a settlement. Lordship, page 74 of the document.
74. Yes,
Ah.
you indicated. Yes.
74. Lordship, kindly consider.
This have been served on Mr. Manager's client and Mr. This is there. You have a copy.
This is the certified copy which, as per the Honorable Court's order, Honorable Court's order, it is being placed.
I see.
Lordship, kindly consider.
Yes.
The order your lordship will find 7/3/2019.
919.
No affidavit is required as well as paper except the.
Very well. When you must have served copies.
Yes.
Must have served copies on them.
No direction was there. Because these are the certified copy, they would have. These are certified copy.
Very well.
Before the
You
tribunal.
have a copy of this document.
I don't know. But I want to know about it. Should have known, I would have probably appeared that day. But I have no.
Signed by SB pigmentation, he can collect it from his own client, he said. That you kindly consider.
No, petitioner shall be at liberty, however, file a supplementary affidavit. Is a supplementary affidavit you have filed?
No, I think by the bunch of documents we have filed.
Is it recorded in any order, subsequent order, Mr. Dev?
Respondent number 3 is directed.
No, no, there is no difficulty if this document is admitted by the other side. I have no
Balancing all documents. It's records of the
Yes.
thing that I won't have.
Yes, yes.
I would like to have a look at it. 7/3/2019. I think in that order. No. Respondent is number 3 is directed to prepare informal paper book annexing all the documents. That is there, which has not been prepared. This is the document.
Page number 40 it starts. So
No, there appears to be direction on them to prepare an informal paper book and circulate it, which has not been done. I don't think there is no direction for serving a copy on that. And Lordship kindly consider only one thing. This is the objection which we have filed. Objection which we have filed with all the documents which my learned friend's client did not annex. That is no. You are not. The union.
There appears to be a direction that he will prepare an informal paper book and circulate.
the matter is proceeding.
Which one?
This matter.
Yes. Before the tribunal is proceeding. Yes.
When is the next?
Fourth tribunal is vacant.
Vacant.
Yes. Is vacant.
Is there any dispute with regard to this, Mr. Banerjee?
I don't know what is there.
Because your arguments are there already on record. No, if this is the only issue, then I'll call for the records.
Yes.
Then I'll call for the records. It will come.
And then we can-
Yes, but yes, so far as arguments you have already made, I'm not recording your concluded. But yes. Yeah, yes. No, I have just, but it is understood that you have concluded. No, I'll certainly, then I'll call for the records. If they, yes. Mr. De, serve him a copy if you have one, or if you don't have, I'll call for.
This is the only one copy I have got.
You should have served a copy, Mr. De, on the other side. It is minimum. Copy you will not serve.
Objection.
Maybe it is voluminous.
Objection copy आपने कितनी? No, objection copy आपने कितनी? No, objection.
Informal paper book was not prepared, forget it.
No.
I'll call for the record. But
I-
if this document has been supplied, not been supplied, then I think you need to supply this.
No, Lordship, I think before the tribunal.
He can just take a copy and serve it.
No, I know that. Before the tribunal, I think the copy was given to SB. It was given to Mr. Northcote. SB is there. This is my objection. So that is the. No, ठीक है. It may not be today.
Very well. Mr. Banerjee, you go through that.
Yeah.
Very well. You go through that. This has been supplied to you. No point.
I'm not.
Yes. Mr. Dey is submitting that it has been supplied. Very well. You go through that. You come back on any day next week in February. I'll put up a date and I'll conclude it.
Yes.
5 minutes either way.
Yes. And Mr. Dey, you have concluded. No, you need to show me 20D
20D
and
settlement.
and this settlement.
Settlement 20D and the report which has been given by the conciliation officer.
Very well. So,
Because I am concentrating on employer.
She wants us to go through this.
No, I don't want you to go through this. If you want to go through this, you are welcome. Otherwise, it is entirely up to you. You tell me, yes, if you want to look at it, you look at it. Otherwise, this court does not want you to hunt up further documents and give any additional response. I have heard both of you. I have recorded that.
Also come back whenever.
Yes,
May-
তাড়াতাড়ি.
Lordship, may I submit only one thing, subject to Lordship kind approve.
12-13 নয়, এটা ছাড়া কি আর সময় নেই, আগে নেই।
Lordship, 9th,
ভুলে
your
যাও,
Lordship,
ভুলে যাও।
Lordship, 9th, your Lordship has
No,
already,
Friday.
no, your Lordship has already fixed a matter of mine. So that on that date,
No,
over
not
that
on a
matter-
Friday. Friday, there are applications, there are other matters.
Oh, okay.
That is only.
Lordship, another thing, Lordship, I want to point out.
Whatever your Lordship.
6 তারিখে লিস্ট আটকাবে এটাকে শেষ করতে হবে।
It is.
Lordship, I want to point out.
সেই 13 তারিখের পরে না 14 14-15 তার holidays. No, কবে
6th.
সরস্বতী কবে পুজো?
11 তারিখ।
Oh, the 14th, 15th.
14-15 is a holiday. 6
After Puja.
that সোমবার। 19th.
Right.
Monday.
Lordship, only one thing has been pointed out by my learned friend, that we have not taken any objection to that when they have transferred it. We have, I'll show the document on that day. It's there in the record. They said
No,
that we have not
no
taken any.
additional documents.
No, already they have taken it. Reply that has to be shown from the documents. It's a record.
I cannot decide this issue.
Lordship. That has been
I
pointed.
will only go by the statements made in the petition.
Yes.
The plain case is there. I will take into consideration that. And he has shown me legal provisions, which I will take into consideration.
Good.
So far as Mr. Banerjee is concerned, Mr. Banerjee has categorically indicated the cause of action, paragraphs right, and the cause of action flowing from paragraphs 9 and 10 of the petition. I'll take into consideration that. Petition means the plaint or the written statement, your plaint and whatever you want to say. I'll also take into consideration the order of reference.
So, Lordship,
And
that
the only question that I wanted to ask, I'll just indicate, Mr. De, that your answer you were trying to give, that this is not the dispute, but you see the dispute is between them. True,
Between them, yes.
correct, true, it is all right. But the only question, important question here would be, and these are the two issues that have been framed.
Yes.
There is no bar in framing any ancillary issue
No.
in relation to this,
No.
although it has certain limitations.
Yes.
Now, while doing so, whether this court can direct you to be added as a party for the purpose of, for the purpose of him establishing his right for that agreement only.
Let me submit only one thing, sir.
No. You answer me on the next
Yes,
state.
yes.
That is a query from the court. That is only to that. You give me a response. I want a response from you. Not that I have decided this or I have made up my mind.
No. Your Lordship has given the
And I'm
Good
confident
of
on
thought.
that.
grateful.
Then, my lord, I will mention the matter.
Take out an application. There is nothing on record.
My lord, I have given notice and mentioned. Now, lordship has the determination. Today, the matter was before my lord Justice Bharodas for extension of interim order. Now, due to unforeseen circumstances, he is now sitting for today and tomorrow. So, my lord, tomorrow is the matter. Interim order is expiring. My lord, I even notice to the other side. My lord, if the matter can appear tomorrow for extension.
In one page application should be filed.
My lord, interim order is existing. It's not that it's expired.
File an application. There is nothing on record.
My lord, interim order is still there till tomorrow. If expired, then my lord, lordship.
I don't know. It is better. I am telling you. You take out one page application. File
Today
it.
the matter was before my lord Justice Bharodas. Just I can remember for extension.
It will appear tomorrow. But take out an one page application. File.
One page application.
Yes, yes. I'll grant you that leave.
Lordship.
One page application, you file it, I'll take it up.
Lordship.
May I seek your lordships kindly to mention one matter, my lord. My lord, this matter had been mentioned before my lord Justice Bharodas yesterday for inclusion in the list, my lord.
This is not a general mentioning time. You should have mentioned in the morning.
Well, that I understand, my lord. We noticed it a bit late.
Yeah.
My lord, this is for withdrawal of a matter. My lord, kindly let it appear tomorrow for withdrawal.
My lord, similar with respect to the first item and for extension of interim order, my lord, it's expiring tomorrow.
Hand over one page application. File it.
Wait.
Bring an item number 1. Yes, issue of court justice as supervisor.
Yes. Dapo.
Item number 4.
Lordship, I'm praying for not today, Lordship. Mr. Anil Gupta is appearing, Your Lordship.
Group,
Mr. Anil Gupta is appearing for
Not today.
respondents, Your Lordship.
My lord, I am okay. My lord, we have filed supplementary affidavit, my lord.
Lordship, there's a fixed.
Which group matter? Group 6. Group 6.
Group 3.
Group 3, you try your luck. Let us see what happens.
My lord, they were supposed to come back with instruction.
Very well. Let us not today. Only not today.
Only not today, Lord.
not
Only not
today.
today, Lord. Let the matter be taken up tomorrow, no issue.
Mentioned, only not today.
Only not today, Lordship. Oblige, Your Lordship.
No.
Item number 6.
Yes. This is that group 6-2. Yeah, the file.
My lord, I am for the petition item number 6.
Last commission, Margaret was asked to directly to staff notice
By
the Army Advocate petitioner result on the very same day on 25th, matter was moved
street dog in the next lane, each under medication.
This is the letter which I have sent.
I'm praying to not be.
What is your claim in the petition, sir? Tell me.
I'm the bound to the petition, bound to the case.
You are the petitioner.
Yes.
Someone else has prepared the petition. Sir, how strange submissions you are making. Yes. Yes, Miss Samanto, tell me. I will take that copy of letter. Letter, give me that letter.
Lord, he also requested me, the learned advocate, praying time on his behalf. Lord.
No, let him. This matter has been settled completely.
Yes, yes.
Over,
yes,
disposed of.
Yes, yes.
I'll
yes,
record your submission and dispose it of.
yes.
What was the claim in this petition?
My Lord, the petitioners before your lordship, my lord, it is a long back issue, my lord. It starts from 1994. They are coming before this honorable court, praying for. They are the librarian of a rural library, my lord. Librarian, they are aiming for higher skill. They acquired the higher qualification, Bachelor of Library and Information Science, and they came before this honorable court, my lord, praying for their highest qualification, my lord, higher skill. This issue was dealt by this honorable division bench after remanding back by the honorable Supreme Court, my lord. Thereafter, this issue.
You are appearing for
Petitioner.
petition. All the petitions.
No.
Which particular items you are appearing?
Item number 6. This is the leading matter, same and identical issue, my lord. Last 1 year, this matter is running before your lordship. It was sent for ARC court or register of this court, my lord. 1 year, last 1 year matter is
So I
appearing.
know. Matter is appearing every
Nobody
day.
is appearing.
Yes. Just Ms. Shamanto, just show me the prayers made in the petition.
Yes. Past matter.
You are Taposh Kumar Mojumdar. You are the advocate and record.
No, Taposh Kumar Mojumdar is the advocate.
What is your name? Very good, very good. Wait, Mr. Bhattacharya. Mr. Bhattacharya, you are Mr. Bhattacharya. Mr. Bhattacharya, this issue has been settled by the Honorable Supreme Court ultimately. That is what is being submitted by Ms. Shamanto. Let me ascertain. Yes. Madam, take me to the prayers.
Yes, ma'am. Page number 19. There. I have taken the first one, brief, Miller. This is Amitabh Mukhopadhyay. Page number 19, prayer, Miller. Direction in the nature of mandamus, directing the respondent, each of them to extend and grant the benefit of higher scale of it to the petitioner for possessing the higher qualification, that is bachelor degree, library and information science, in terms of subpara 3 of para 16 of the memorandum dated 33 AD dated 7th March 1990, issued by the Secretary Education Department, Government of West Bengal, and the corresponding high scale of pay under division of
Correct,
pay and
very well.
expenses.
Now what happened? The first order passed by the learned single judge.
And in this matter,
Yes. No, not this matter.
all the matters,
Identical issues. Yes.
identical issues, my lord. I have handed over, my lord, the
Justice Datto's order is there.
Yes.
Justice Sen's order is there. Division bench.
Dipankar Datta's order, received the division bench order after remanding back the Supreme Court, my lord. Issue went to Supreme Court thereafter the total issue was.
Then what is before Justice Sen? Division bench.
This is second part of this matter. Those who are within not the cutoff date is 21st July 1990. Those who are within not the cutoff date, they came before this honorable court for high scale of pay.
No, what was directed? What the division bench directed?
First I am the Pradeep Karak.
However, those librarians who have acquired higher qualification
Malad,
before the cutoff date, that is on 21st of July 1990, are entitled to claim and be treated at par with the librarian, Shivnath Kole and others who were before the Honorable Supreme Court in civil number such and such. Civil. In the first state in its counter-affid before the Honorable Supreme Court was also candid in its stance, and at least some of the appellants were entitled to better pay based on higher qualification. But
my lord is reading the judgment of Pradeep Karak.
yes.
Yes, my lord. It starts from, my lord, the operative portion.
Very well. But one thing is there, Mr. Bhattacharya, you are not aware of anything in this matter.
No, I think.
Then Ms. Shawan to come tomorrow. I'll make this not today. I'll record his submission. I'll make this not today. This is a group 6 matter. Or group 3.
Group 6 matter, my lord. Group 6.
You know, determination আছে অন্যগুলো তো নেই
Group 6 matter. Please bring Milan. Next week. Nobody is appearing last 1 year. Which one, Milan? The relevant person? Or not the- And that part of duty was the inactive line. You lot me kindly have a look. I have prepared it chart according to this list method. He acquired this qualification 2000. This is also not annexed in this writ petition also. It was annexed. The Master of Library and Information Science. It is my lord page number my lord 25. It is absolutely. This is also the this judgment which was delivered by Honorable Justice Doctor. It's supporting this judgment, and also it was dealt. Same point was involved, same issue was dealt by this Honorable Justice. It was also decided in this judgment who acquire this qualification after the cut-off date, they are not entitled to this benefit. My lord, kindly have a look at page number paragraph. 137. This question those licenses acquired have conflict after but 99 and for enforcement of unhappy paragraph and the basis that was called the was not be as a great license right then after the started first 99. It's also there in the from number 126. 120, 120 paragraph, 126 paragraph. It's first. They are not impacted. Uh, they are they are 18 transform too far as the accepted that was we are not two epics for they are also two epics like it separate. First epic state of once required by the repetition and one state. The hard element. That is the state. We pass to another also which is also already done. One thing can be charged. Right hand side, we take up the apple. Start minute. Why this judgment which I have handed over. First name is not fully correct. That's all. Yes, so the curve our giving the benefit. That's why we so we have a study. They are effective. Not in this start, was have the qualification, the cargo grade, they got their benefit. Other students, the paragraph on the product. After demand, the total issue was there. This is for the current values. Yes, and order of this is before for the current. This is before for the current. Yes, this is the order of the market. Yes, yes. Yes. This order is also. Thereafter, this matter was two issues that who acquiring the higher qualification before period and who acquire the qualification after period. Two separate judgments were delivered by the same rules. From the above chart, which is based on the fact of number of the that we have 153 not have the itself and not have this result. Which was clearly long before related to first and so far as the evidence is concerned. The only particular of acquiring the qualification is 1990. Here is also mirrored. There is no date. My issue. My all the matters. These matters. Painting. And they have annexed all the papers in this every repetition. I have also prepared a chart particle. There is no need of filing here. But only in this, those matters are appearing before the lordship. Only two matters. There is only qualification is 1990. There is no date. No, no. I have taken. I have collected only the month July. One matter and one matter I do not have any. Only two matters. Others are not entitled. Only two. There is a date 1990 pass of this landed authority. The we cannot say. Mala date is 21st July. Date is very vital. 21st July 1990. Because of it. July means it may be 1st July. It may be 31st. 30th July. But my contention is it must be 21st July 1990. Here means that I have collect one matter. This is July 90, and another matter only the year. Others they are not. Lord, you will. I think you will not say anything. My lord, I will collect. I will collect. I will. Fine. Fine. My lord, paper is here with before your lordship. No, no, no. No question, my lord. We are always no question of rejection, my lord. Judgment. They got my lord. He's saying no, there are others. Yes, seven except your lost in a kindly others. There is no necessity. Only two matters. Yes. Two matters, my lord. Yes, yes, yes. I have handed over. My lord, I have no. But my humble request before your lordship that this judgment, this is the historical judgment. If your lordship kindly have a look to this first line of this judgment, where it starts from the keepers of the place of knowledge have come to the truth, complaining that they are not being paid enough compared to the additional qualification they have earned after securing employment. Not first line that if your lordship kindly have this and another also same bench, same day. Yes, same. Two bunch of litigations. This is also reported judgment. This group are after the cut-off date. This was also dealt. Next twisting. My lord, kindly have my lord. My lord. And in the two matters, I have also My lord can dispose of, except two. Number 18 and number 24. My lord, necessary. Yes. Supreme Court পর্যন্ত order My lord, I am appearing led by Mr. Sheshanaganda. My, my, my lord. My lord. My lord, I am also due to want to. My lord. First requisition, page number. Yes, 25. My lord, this is annexed the Master of Library and Information Science. Bachelor of Library, he has not annexed. It is 2000. I have taken the instruction from the district library official. He has not annexed. This is the Master of Library. After that, this is 2000. My lord, criteria is Bachelor of Library and Information Science. Yes. Yes, my lord. This is created. He acquired, my lord, all the repetition. Yes, I have all the serially I have written. This is number 6. Next matter. Yes, it is here. My lord, page number 538. Apartment is there. Bachelor degree in Library and Information Science held in 2002. The wrong statement. It is 2000. I have taken instruction. Which chapter? The which, he has annexed. Which one, madam? 2000. He has not annexed. I have. He has stated in paragraph 3A, wrong statement, my lord. He has not stated. Qualification, master degree. Before master, 2000, my lord, but he has not annexed, my lord. How? My lord, I have taken instruction from the office. Yes, no, no. My lord, I will bring, my lord, I will. This document, producing this document. Document is with the office. Then I. Yes, madam. Then other matters, all the other matters he has annexed, but in this petition, this page is missing. Other all the matters, yes, yes. Next matter, next page 26. Somehow he is managed. Page 26. Page 26. Number 7. P3. (26) 2000. Right hand side, top. Certificate. Commission transfer permission. Yes. Next page. Order date is September 24, 2018. Next one, page number 25. Montu Chandra Ghosh. Page number 25. Ninety-nine. Page number 26. Twenty-six.
No, I'm attending only my senior apparently, what is get number 28,964.
So item number 6. Perhaps. Nobody appeared last. No, I have written this, his learned senior, so that I do not know. I think he is appearing. হ্যাঁ 26 26 to page number 27. Twenty-seven. Page number 26. Twenty-six. Page number 26. Twenty-six. Page number 25. Twenty-five. Twenty-seven. Fifty. Twenty-six. Twenty-four. Passive. বলে দিচ্ছি। This is 24 page. Page number 24. This matter, which I have mentioned, page number 24. Here is 90, examination, July, 24 months. Date is not available. I am leaving it. Date is Yes, I have already mentioned before you. My lord, kindly pass necessary order. Yes. My lord, pass. My lord, kindly pass. I have first mentioned before your lordship this matter. Page number 24. I have checked it, my lord's file at the time of recess. 2003. Of 23. 23. Huh? This is the last match. Yes, yes, last match. Public publication of the this matter. I have already informed the authority. Find out. Two matters. Yes. Annexing. No, no, no. I'm. Yes. Month, earlier matter, month is mentioned. Here, month is not. Yes. Then, affidavit file, my lord, gives up. 15 days time at least. No. By मतलब by Tuesday it is not possible to find. Fine. I would also talk to the director of bibliothèque. Ask him. No. I will in the meantime I will talk to the director also and and my in two matters, मतलब separate order. In these two matters, which are if online order, it is very to take instruction. Fast. 18 and last matter. 18 and 24. 18 and 24. And first one is also not disputed. First one, they have three matters. These three matters. Other matter. I have already found this one. One. चलो Lordship, finding the affidavit in opposition which had reaffirmed procedure. He kept on record. Keep
it with you. I'll take it up. The first matter and not today I'll make. Not this week you want. What do you want? But this will go to the next monthly list in that case. You don't want to do it. You don't want to do the matter. Come tomorrow. I'll do it. I see. Yes. Very good. Lots. তাহলে একটা লাইন ওপরে নিয়ে নি দিয়ে দাও affidavit in opposite pursuant to the order dated দেখি অর্ডারটা দেখি দাও দাও
November.
pursuant to the order dated 23rd November 2023 the reaffirmed copy of the pursuant to the order dated 23rd November 2023, the reaffirmed copy of the affidavit in opposition filed in court today is taken on record. Post of the affidavit in opposition.
To the original.
The affidavit in reply filed on behalf of the writ petitioner is also taken on record. Madam, this is the reaffirmed copy.
This is the reaffirmed copy. He has filed a reply to the original, but it is identical, Lordship. I haven't changed anything. Like accepting for adding a paragraph.
Reaffirmed copy
That
of the
is
original.
affirmed pursuant to your Lordship's leave. The rest of the
Original.
affidavit is identical.
Original reaffirmed copy. The affidavit is. Therefore, again. Yes. I sprayed for list this matter in the monthly list of February or March.
Month.
Okay. ওখান থেকে না যতগুলো
On the last occasion, your lordship directed to file the affidavit in opposition. Draft is ready, my lord. So kindly, some time is required, my lord, for affirmation by the concerned department. Lily biscuit matter, my lord. Next week, no, next week, I will file this, my lord.
Accommodation. Now, prays for an extension of time to file the affidavit in opposition to the supplementary affidavit. Full stop. I'm extending by 1 week. Considering the submissions made, let the time to file affidavit in opposition to the supplementary affidavit filed on the behalf of the petitioner be extended by a period of 1 week from be extended by a week from date. Full stop. Reply, if any, there to be filed
Within next week, my lord. Within next week, I will file, my lord.
within 2 weeks thereafter. Full stop. Within 2 weeks thereafter. Parties shall be at liberty to mention the matter. Parties shall be at liberty to mention upon completion of the liberty to mention upon completion of the period for exchange of affidavits. Not within next week. Within a week from date. Within 1 week from date.
My lord.
The direction is peremptory.
My lord.
No, I cannot take up anything.
No, Judge Sahib ko bolo na ge.
The direction is peremptory. Keep it with you. এরকম ভাবে হবে না, আপনি রাখুন পরের দিন যখন মামলা আসবে আপনি মামলা না এলে মেনশন করবেন 3 সপ্তাহ বাদে। যদি মামলা না আসে, মামলা আসবে না 3 সপ্তাহ বাদে, 3 সপ্তাহ বাদে আপনি মেনশন করবেন। 3 সপ্তাহ বাদে আমি মেনশন করবেন।
Deeply obliged.
But I for the petition.
But I am for the response.
What is this matter?
Well, the matter about is about the petitioners, the losses, all are ancillary stuff under the Railway Protection Force. Ancillary about Safai wala, cookmate, and my lord, they have joined India 2007. So at the time of joining, my lord, there is a provision of change of cadre from Safai wala, ancillary staff to my lord, executive constable.
I have raised the maintainability point. The writ petition, no
2016 maintainability.
After 2016.
My lord,
Mr. Ghosh.
thereafter, my lord, the matter is hard. That is the first time. 2 time matter was dismissed for default.
My lord,
1 time was
previously, my lord,
restored on the request of the learned advocate of the petitioner.
My lord, the matter was, my lord, this last occasion, my lord, before the honorable was heard at length. My lord was about to pass the judgment. At that time, it was pointed out, my lord.
That was application was hard.
For that reason,
I have no objection, my lord.
You see, difficulty is
No, I have no
16 matter.
I have no difficulties. I am ready. My lord, difficulties is this, my lord. Earlier advocate filed 1 affidavit in reply in 2018. Thereafter, change advocate filed another affidavit in reply
as per order of this court.
of 2023. And my lord, without having any order, they have filed a voluminous supplementary affidavit recently.
No, there is no supplementary.
But I have. But if
there is no order.
If he not press, I have no objection.
No, I will pay. I will pay leave.
I did not grant any leave.
So I till now I didn't pay for leave.
I have not granted any leave.
But in the year 2007 they joined. But at the time of joining, there is provision of change of cadre from cookmate Safaiwala to constable executive for better promotional aspect. And in 2012, the circular is issued for change of cadre from ancillary staff to executive constable. They have made and submitted an application and they are shortlisted. And 2012 it was going on. In the meantime, in 2012 to 2015, different other railways, excluding the Eastern Rail, North Frontier and other railways, the persons who have applied and shortlisted, they have been promoted to the higher post as executive constable. But 2015, 16 January, when suddenly one circular was issued that the directive is there. Well, as per Rule 28, the Director General withdrawn the directive. You are no longer be entitled for change of cadre. And we challenged the application before the lordships in 2016. And one of earlier occasions, the matter was heard before the Honorable Justice, of course, another bench, the Justice Fina, and one of the Mayor was pleased to pass the judgment. At one point, it was found out that no reply was there. And Mayor directed me to file evident reply, and accordingly, I filed the evident reply. So was the page 96 of the writ petition, Mayor find the Senior Deputy Security Commissioner. He has simply 4-line order on the basis of the page 96. But in view of the clarification of railway boards by letter number 2006,
Just 1 minute.
Madam.
Mr. Ghosh, what is your objection as to the maintainability? Why is
Reply. My lord, I have no
what is your
objection.
objection as to maintainability?
My lord, no address of the writ petitioner is there. Kindly see the first title of the writ.
Supply that. Okay.
First title of the writ petition.
You have awakened from your slumber now. After so many years, after 8 years.
No, my lord. Actually, thereafter the first day, thereafter another day matter was heard. That was heard on application. I have raised that point. And the Honorable Justice Amrita Sinha directed me to you raise all the points when the main writ petition will be heard. And my lord, now they are not posted even in those places, my lord.
This is was at that relevant point of time posted there.
My lord, thereafter, my lord, for this reason, affidavit and opposition was, my lord, direction was given. That was long back ago in the year of 2016 or 17, my lord.
Now, if he is residing there,
Your lordship,
no, if he is residing in a quarter, Mr. Ghosh, that will be his address.
my lord, your lordship, my lord, I shall
No,
be
I'm-
grateful if your lordship dispose of this matter, my lord. I shall be.
I'm trying to ascertain from that if he is residing in any quarter there, that will be his address.
Yes, my lord.
If he is residing in any quarter,
Hmm.
will that be his address?
Yes, my lord. That
So
was
that will be
addressed
his
and
address?
subsequently at
So what other address will he indicate?
my lord, for the this reason, my lord, the direction was given for filing the affidavit, taking all the points, my lord.
So you have taken all the points. I'll consider this
Yes, my lord.
finally.
Yes, I shall be my very first submission. I shall be grateful, your lordship, if your lordship dismiss or disposal or anything. My lord, at least, my lord, one matter should be sorted out before your lordship. I shall be, my lord, very much happy whenever, my lord, I shall appear before.
Now itself. I'll try to
Yes.
clear out the. Continue, Mr. Pai.
Well, the order is at page 96, the impugn order which are challenged before your lordships.
Yes.
In view of clarification of railway boards by letter number such as dated 28/12/2015, the earlier notification issued and circulated by IG cum PSC by letter number such and such dated 17th March 2015, duly communicated by this office by letter number such and such dated 17th March 2015 for filling up 56 vacancies of constable RPF by change of cadre of RPF. Following staff to the rank of constable RPF is hereby cancelled. This is ballot cancelled. So we challenge it before your lordship, before this honorable court in the year 2016.
You're challenging this communication.
But this is the order that we have challenged, and when we challenge the other provisions also, that Rule 20, they said, as per the Rule 20, the Director General is empowered to pass directives. Accordingly, the Director General passed the directive.
What is the railway board's letter dated 28 December 2015? Where is that?
Well, this is the page 95.
So these persons, their names were already there, but this was prepared.
That was prepared. Well, I'm showing well the list. So they have well the prepared.
Show me that.
Well,
the list was already prepared.
We already prepared. Well, by
Where is that?
It starts from page 90. It starts from page 90, 25th June 2015, and what the list is as well at page 91 starts. But the latest says, my lord, Senior Division Security Commissioner, as intimated, change of cadre of followers ancillary staff to the rank of Constable Executive. Then, my lord, reference as intimated by IG cum CSC such and such on the reference that total.
So after the selection test was complete, then this was withdrawn.
This is withdrawn.
Yes, Mr. Ghosh.
No, my lord. Actually, what happened? There was a directive issued by the Director General of the Railway Protection Force. My lord, he, according to the section 28 of the Railway Protection Act, he is empowered to issue the directive, and at the same time, he also have the authority or jurisdiction to withdraw the.
Correct.
Yes.
He can withdraw. There is no difficulty. Whatever right has been created in favor of these persons, that may be made effective for future persons. Say, for instance, certain persons have been given certain benefits. I mean, consider selection process was held, selection test was there. They became successful, and thereafter, how can you deny that benefit, Mr. Hu?
My lord,
no
selection process.
It's shortlisted. They are shortlisted. But thereafter, my lord,
no selection process, no written test was held.
Not necessary.
My lord, only notification was issued, my lord, declaring the vacancies. That was held only. Thereafter, my lord, nothing was held. Thereafter, my lord, the
What is the reason to withdraw?
my lord, reasons was withdrawn. Reasons behind that, that initially there was a no scope of my lord, the advancement of their pay scale. The MACP scheme was not there, and thereafter, my lord, that scheme was introduced by the railway board. So pay upgradation scope was there. For this reason, my lord, I have annexed that.
Very well.
I have annexed that, my lord. That my lord, kindly
Mr.
see.
Pal, I'll place it on in the supplementary list. I'll take up this matter. But
Supplementary list of my lord next week.
next month,
Next month.
I'll take up this matter.
Today, even my lord, I am ready, my lord.
No,
So
original
original
set,
set 30. Original set.
Very short matter. Matter is 5 minutes. I shall not take my lord more than 2 minutes.
I will take
If,
some more time.
if I shall take 2 minutes more than my lord,
You
today,
know the matter by
will-
the tip of your fingers, but I do not know. So I need to satisfy myself before passing any law or to dismiss the both these. Heard Mr. Paul, learned advocate, heard the learned advocates appealing for the respective parties who stop place this matter in the daily supplementary report. এটা এখন শুরু করে কি কদিন বাদে দিলেও supplementary list দাও। না না তারপরে কপি দাও তারপরে দুটি পর উনি
Original copy দেওয়া হয়েছে। দিচ্ছি দেখতে পাবো।
very fast. Install it.
But may I pray for leave for to style supplementary?
No.
Disclosure is that, my lord. In the year 2018, change of character is permitted by the railway board. That documents we have received, my lord, 2022 they have appointed. That's their documents, not my document. We have
I don't
collected
know,
this
my lord,
document to
they-
show your lordship what way, in what manner the railway authorities are acting. Because we are the lowest grade for that reason. 2017 to till date, my lord, we are in stagnant position. We have no prospect.
When was this allowed? Which paragraph you have stated?
Copy that. But kindly see the annexures, copy it out.
Take instructions from this instrument.
then my lord, I don't know, my lord, it is related to the various other zonal railways.
Let it take instructions. As straightforward leave is granted to the petitioner to file supplementary affidavit, with petitioners to file supplementary affidavit. Let the same be taken on record. Cost of liberty is granted to the
My lord, after my lord, 2016 petition filed and
Sir, take into
2023 this affidavit. And my lord, then my lord, kindly allow me to file the affidavit in opposition, my lord.
to use an opposition to the opposite supplementary affidavit. Full stop, let such opposition be filed on or before the returnable. On or before the
With-
matter is taken.
Within my lord,
On or before the returnable date. Nearly a month from.
my lord, actually, my lord, those are related to the various other railways. My
You
lord,
are having to take you.
it will take some time, my lord, at least.
It's, I think the sufficient time.
My lord, kindly see what is
21st
the
your
date,
matter will
what,
appear.
I don't know what is the date.
21st your matter will appear.
My lord, I am praying, my lord, at least 4 weeks time.
No, enough time.
My lord, that 17 to 18 documents they have annexed now.
You take instructions.
My lord, I shall take instruction definitely. But my lord, those railways are not party here. Only the Eastern Railway is party.
So you say so. Not applicable. I do not need to tell
Oh,
you,
my lord.
Mr. Ghosh, what to.
No,
How do you want to defend your matter? You can defend your matter very well. I think you are.
For this decision, my lord, I am praying, my lord,
No, no,
4 weeks time to
no,
file
not
an
this. It
affidavit
will
in
be there on 21st. Take appropriate instructions in the matter. Get hold of your officers, bring in the records. Everything is
my lord,
possible.
my officers are related to the Eastern Railway.
Naturally, you answer apropos Eastern
But
Railways.
those my lord, documents
Are
related to the
supplementary.
Delhi, Jaipur, Rajasthan, those my lord, related documents are
Say
there.
that it may not be relevant. Indicate that.
So, my lord, I have to take instruction from those
Naturally.
railway also, whether that was really happened or if it was happened on what basis it was happened.
Internet, you cannot say that you are not getting information or the officers are not giving.
No, my lord, those related documents, I cannot, my lord.
Sufficient time you have, I think, Mr. Ghosh, make an endeavor. We shall see if it is not possible. Make an endeavor.
My lord, my only prayer is after 2016, in 2024, they're filing the supplementary
going to
affidavit. I am praying only 4 weeks time, my lord.
No, it's all right. Come on 21st. We shall see. We shall see. Yes, call the original side. Okay. Original side. Who is appearing on the other side? এটা পরেরটা not today করে, not this week করে দাও।
Last professor also carried to submit the document. At the documents,
And he is not well.
yes, I know that.
And they have to mention the matter to urgent determination of common Ramadan unit. And therefore, it is running tomorrow.
Was it appearing in the list?
No, it is not happening. It is due to be listed in February monthly.
Notice.
I have said both are not.
Then how did you, did you not mention the matter?
I was due to mention this Monday, Your Lordship, but on Friday evening we came to learn that His Lordship will not be sitting. We went to mention to him before the Honorable Rajasthan Bhagwati, who was having written yesterday, but second half, Your Lordship, His Lordship did not take Your Lordship. We had made a representation to the original side, Your Lordship, to recruit one original side officer. He came, Your Lordship, but the Honorable Justice did not say. The officer went and talked to His Lordship. His Lordship said directed us to mention the matter today, but His Lordship did not say today. So that is why I am mentioning it too. All right.
The original side is determination, I think. Just a minute. What I think? আমি তো অরিজিনাল সাইড দেখ ওটা তো অ্যাপ্লিক সাইড ছিল দেখছো তো ঠিক আছে চেক করে নেবে কিন্তু অলরাইট yes
My lord, the last order, my lord, has given certain direction upon us, my lord. The order, my lord, we
you
got
want to
it.
go to that is a liberty.
Yes, no, my lord. There was a direction. Kindly see, my lord. My lord,
I asked you to produce the
yes,
record.
yes, to produce the record, my lord. I have come
For
get
your
hold of the yes.
Only
Get,
for your
yes,
benefit.
yes. Get hold of the concerned person, my lord. They said, man, the MD WBTC, who is my lord, their department
That
is
record it is not available.
looking. No, there are records, my lord. They are looking after all the records relating to the writ petitioner, my lord. So, my lord, they are bringing out all the records, my lord. They are today, my lord, they have got the order. Now they are making the correspondence. But today, my lord, it was last night. I personally checked; it was not there. It is uploaded, my lord, this morning. If I am not wrong, my lord.
24th January order.
Yes, my lord. And in Markadi, my lord, that I follow.
No, but still then.
Yes, but today,
you
my
were
lord.
aware of this order. I passed
Yes,
this order.
yes, that was. My lord, today, my lord, they are.
No,
making,
that is all right. Matter will not.
They are making, my lord, correspondence, my lord, subject to lordship 7 days time, my lord. I think the record may come. But because they are making the correspondence in course of today, my lord, after getting this order to the
Everyone has to
MDWTC.
move so late.
My lord.
Everyone has to move in such great speed that you cannot bring in the records. From where will the records come, Mr.
But it is WBT, MDWTC, their department.
Where is that?
Managing Director, West Bengal Tram Company. my
Where
lord.
is that? Where, no, where is that?
কোথায় আছে ওটা? Mangoland. But at least they will approach.
7 days time to communicate, then another 7 days time to locate, and then another 7 days time to again transmit the record.
Let there be 3 days time if you lot.
Why? Why 3 days? Tell me why 3 days?
Kindly
should have been
appreciate, they
here
have
today.
Yes, yes, should have been here today. Yes, my lord.
Especially when you are seeking this opportunity in this fashion.
Yes, my lord.
You are seeking a liberty to rely on documents, whatever is there.
But I had already relied on, my lord, the memorandum.
That is
my
why
lord.
I granted you leave.
Yes, 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 my lord. But any further documents relating to my lordship wanted
You
me to-
cannot just wait today. You whatever records are there, Mr. Roy Choudhury, records are there. Whatever is not there is not there.
Yes, my lord. And my lord,
If there are certain records, Mr. Roy Choudhury,
I
they are
prayed
there.
for since the
If
matter
there,
waited.
there are no records. They are not
No,
there.
no, no, no. What can be done, my lord?
What can be done? So
It will
then
be on the based on the materials available.
your client should have given you this instruction.
For the
Not
instruction is covered. I
You
have
must
to
come tomorrow.
cut a sorry figure, my lord.
What can be done?
My lord, then make it day
No,
after,
no.
my lord. Day after, my lord.
No, certainly not. R.N. Mukherjee Road.
Yes, yes.
Don't even utter this, Mr. Roy Choudhury.
My
R.N. Mukherjee Road.
Yes. I should know.
It is
R.N. Mukherjee, yes, my lord. I even
the
give you-
records cannot come from R.N. Mukherjee Road. And if you want it, and if you say there are no records, I'll record and produce.
That also, my
Suppose
lord,
if
they have to give in writing. Thereafter, I will believe.
Yes.
It's the
ask
official
them.
thing. Official thing. Yeah, I have asked.
And this is only because, Mr. Roy Choudhury, you intended to rely. So I give you this opportunity.
But
Whatever.
I wanted.
Since affidavit is not there, that is the reason why I give. Now, if today you cannot produce the records, then no point.
Since my lord is allowing me, my lord, allowing me to rely on documents.
Mr. Roy
at
Choudhury.
least- At least let there be my stand on the record, my lord.
Mr. Roy Choudhury, learned advocate. Mr. Roy Choudhury, learned advocate, representing the state respondents, prays for an accommodation. First of, he submits that the records prays for an accommodation. First of, in view thereof, let this matter stand adjourned and appear under the same heading tomorrow.
But day after.
No, tomorrow. I made it very clear. I have not recorded the
I will not participate. I have
not recorded the records have not been produced.
I should not.
I have not recorded that.
If it has fallen from your lordship, it has fallen.
You see, 20.
It has fallen. No, no, man.
Today we are on 29th. We are on 30th. Records should have been here. Should have been.
Everything.
And every day, this is good. This is going on. If you are not interested, tell me. I will just record one line that there are no available records for being produced.
Kind of not. We tells many things before the court. We leave the
No.
court.
At
Many
the
things
end of
are
the day,
untold.
Mr. Choudhury, at the end of the day, I have to
Many
dispose
things
of the
are
matter on
untold,
the
my
basis
lord.
of the available records. Whatever is available, I will
Yes,
dispose
yes,
of.
my lord.
So if I have given you an opportunity, if you
But my
want
lord,
to
only one thing that I am missing, my lordship has given me enormous opportunity, all of us.
very
But only one thing, as you.
come tomorrow. এটা কিন্তু specially fixed থাকবে।
Yes, yes, my lord.
Difficulty is because of this,
But
the other
difficult-
matters are fixed, which will suffer. There is another matter which is fixed tomorrow, which will suffer. Yes.
Not that matter, not 4 matters 2 to 5. But I've checked it, not my lord has determination to take it up. Kindly see this. The last line notification, last line of that page.
This is 2007, 15th of March 2007. Yes, Mr. Jena.
Yes, that is an application for recalling, that is a separate. I do not know what is the distinction between the restoration and recalling. Unless it is recalled, the matter will not be restored.
No, you want to make
Order has to be recalled. Then the writ petition will be restored to its file. It's my I do not know, Malad, it's my understanding.
Yes. There is a, what do you have to say? There is a.
But anyway, Malad.
No, there is a application for condonation of defect.
In original side, application for condonation is not required.
No,
it can be done in a simple one application for
But
dismissal.
there is an application for condonation
Yes,
of
filed.
delay.
Yes, filed. And
Yes. So therefore, are you opposing?
Malad, Lordship kindly appreciate that 2020.
No, if you want to oppose, you have to file an opposition to that. Very clear.
Because since I'm statutory body, my lord.
No, that's why I'm saying, if you want to oppose, you file an opposition to that. Thereafter, I will decide this.
Your lordship can't pass the note. I will not
No,
consent.
it is entirely up to you.
No, I am not giving any consent.
No, I will record that. You do not want to file out.
Because, my lord, in this age, my lord, I should not. No.
Yes, show me your statements.
Lord,
If
I
you
consider
want-
it a
I'm kindly see, my lord, the first thing that there was a order for hearing of 3 repetitions analogously, and Lord, if I'm not wrong, it was further mentioned that the
You told me this yesterday. Mr.
yes. Now next, my lord, the order, these 2 repetitions appeared one after another. We missed the list. It's an admitted position, and the order of dismissal is on 25th July 2023. 25th July 2023. That is the order of dismissal. Lord, that is annexed P2. 25th July 2023. Thereafter, Lord, within the statutory period of 30 days, we took out, Lord, an application for restoration. Problem is, Lord, it was absolutely my fault that I filed it through me. So, Lord, the registry did not accept since I was not having the Wakalatnama. So, I checked it up and it was found that in one matter, Mr. Sani Nondi is appearing and the other matter, Mr. Sommo Mojumdar is appearing. So, Lord, again, I have to prepare the Wakalatnama. At first, I had to obtain the no objections from Mr. Sani Nondi as well as from Mr. Sommo Mojumdar.
Where have you pleaded that?
prior to that, several times the matter was dismissed. Several times adjourned. Several times.
Where have you pleaded this?
Sir, I have kindly come to kindly take up any of these applications.
Yes.
Not any of these applications, things are same. Lord, that thereafter the writ petitioners, paragraph 4 onwards. Paragraph 4, that thereafter the writ petitioner affirmed a restoration application on August 22, 2023. That is,
Ajay, this is which group?
Lord, this is your service under group 6.
Very good.
Within the prescribed period of limitation through Sanjeev Kumar Mukhopadhyay, learned advocate. With the understanding that the said learned advocate would obtain a no objection certificate from the erstwhile learned advocate on record and shall file the same in the matter. Which happens usually in appellate side matter, so that the delay can be condoned. Thereafter, Lord, that despite much pardon, the department did not accept the state restoration application since Sanjeev Kumar Mukhopadhyay was not registered in the original side of this honorable court.
Correctly answered.
Absolutely, I'm. That is why
You should have.
Where
is that letter? Where is that letter for registration asking for it?
No, that is why, Milord, I
You recently gave that
requested my learned sister to take up the pen to file the Wakalatnama. That is why I requested my learned sister, Milord, to appear. Because she was having that enrollment in the original side, registration. Then on September 8, the state learned advocate, namely requested the present learned advocate on record to appear as advocate on record in the matter. Next, Lord, that the present learned advocate on record for the petitioner on September 8 requested the petitioner and his learned counsel to give copies of all the 3 petitions as well as other relevant documents to her so that she can make herself acquainted with the facts of the present case. The 3 voluminous petitions. Next, Lord, that on September 22, 2023, the present learned advocate on record for the petitioner, after going through all the papers of the 3 petitions, agreed to appear in the matter and requested the petitioner to give her at least 10 to 12 days time to prepare the restoration application along with the application under section 5 of the Limitation Act 1960 and to get the same vetted by the petitioner as also by the learned counsel appearing in the matter. Then that accordingly the petitioner was requested to come to the honorable court premises on October 5, 2023 for the purpose of affirming the restoration application along with an application under section 5 of the Limitation Act. That in the process there is a total delay of 41 days.
No, one thing I am very interested, Mr. Kovatai. Paragraph number 6, you see, September 8, you requested her. September 8, you gave her copies.
Yes. And September 22. And yes, complicated law points are involved.
For preparation of the
recalling.
No, not for recalling, Milord. What my learned friend has pointed out. These repetitions, Milord, 3 repetitions are there.
When did the advocate and record file its wakalatnama?
No, on the same day.
Where is
So that is on October 5, 2023. Kindly see. October 5, 2023. We all the three things.
so
because
why did he take
that it would have been similar. I myself
nearly a month to file the wakalatnama?
well, the Vokalatnama, we have to ascertain, who is in the power. Thereafter, we requested the client to take the no, he prepared the no objection, and thereafter, he is a senior citizen, aged about 70 years. He came and he took the matters to Kamat, and then he.
Where is that statement?
That is not there, but usually what happens, not that he obtains, he himself goes to the chamber of the erstwhile advocate, gets the no objection and gives it to us. And then we have filed.
In original side, the list name mentioned, always the matter appeared.
Yes. That is there. That is there, but usually even if we file, even today after filing of this Vokalatnama, kindly check it up from the list where the name of my learned sister is appearing as an advocate.
Why it should appear?
Kindly see. If I am not wrong, subject to correction by my learned friend, এক নম্বর আজকে দেখুন তো আজকে
No, let the name of the advocate and record be corrected.
Yes, Lord.
Mr. Mukhopadhyay, learned advocate, appearing for the applicant submits that the cause list is not
objection
reflecting the name of the advocate and record. However,
আমি তোমাকে অপোজ করছি
name of the
অপোজ
advocate
করলে
and
অনেক
record
কিছু বলতে পারি
submits that the name of the advocate and record is being reflected in the cause title. So having regard to the aforesaid, the department is directed to ensure that the name of the advocate and record appears in the cause list. Advocate and record for the applicant, one applicant appears in the cause list. When the matter appears in the cause list, when the matter appears in the list, next, full stop. List this matter under the same heading on Monday. Next one.
But the affidavit of service we kept it.
No, let it be corrected. This is a very serious mistake. And you see, difficulty is, if with this cause title, this is dismissed. This is the sufficient ground for recalling. If tomorrow you do not appear and this is dismissed with this cause title, this itself is a ground for recalling. Because in the original side,
Is a very
the advocates check it by their name only.
yes. And that is why I committed that mistake. I was under
Initially, when the matter appeared before Honorable Justice Anindra Roy, the name was there. Sunny Nondi and other advocates are there. They did not appear several times.
no.
And once they appeared for taking necessary instruction.
Let us not go to that
No, no,
extent. You see,
be that
advocate
as
was
may-
appearing.
Be
You see,
that as
advocate was appearing.
no, be
He
that
is
as
not making any
Lordship,
allegation
kindly
against the
restore,
advocate.
kindly restore
Therefore,
it.
Sunny Nondi's
Fix the matter for you.
presence is not necessary.
Well, not necessary. I am not opposing.
I'm also requesting.
He has not made any allegation. He says that there were problems and he missed the matter in the list. He is taken on himself. We shall consider it on Monday. But let it appear with the correct cause title in the list. Now, since it is pointed out, since it is pointed out by Mr. Mukhopadhyay, learned advocate representing the applicant, that the name of the advocate on record is not appearing in the list, the department is directed to ensure that the name of the advocate on the record of the petitioner appears in the list when they appears in the list. List this matter under the same heading on Monday.
Well, tomorrow that state government matter will be continued. First matter, today especially.
I do not know whether the records come or not.
Even if records not come, that they will make submission.
I do not know.
Tomorrow I may have some difficulty.
Ask someone to mention.
If I will there, then definitely.
Ask someone to mention.
With your lordship.
Item number 6.
Six. So may I attend for the respondent number three? The lawsuit already about the matter. Since other side was not present, I served the copy for our side. Now, in this matter, you know, 6-7, that December 9. But I have challenged the award passed by the industrial type. Admittedly, I have served more than 12 years uninterrupted. And I have been terminated from service by way of refusal of employment. I raised the dispute before the Labour Commissioner, and during pendency of the matter, I obtained certificate under section 10(1)(b) of the Industrial Dispute Act. But both the parties filed their respective statement and evidence. And on the basis of the evidence and the statement of claim and written statement, learned tribunal hold that I am not entitled any relief. But before that, it's most important that I have been terminated violative of principle of after violative principle of natural justice. No charge sheet, no show cause, no domestic influence, even without compensation as per section 25A of the Industrial Dispute Act. But in this matter, learned labor court held that I am a workman under section 2S of the Industrial Dispute. But kindly see the first before that I should come. But what is the issue?
This is a group 3 matter. You'll conclude it today. If you cannot conclude it today, tomorrow, I don't. So, I have to hear him. That is the reason. If it can be concluded, Mr. Rocky, then only I will take it. Because you see, I remember the matter.
I will conclude.
No, he is there also. From tomorrow, I don't have determination. Perhaps there is some change.
Already at
There is some change. Perhaps.
that
Someone is telling
lordship
me.
already allowed this matter. So,
No, I can only take up provided I have determination. Mr. Rocky, you are ready. No. So, if you can conclude it, I will. Good thing. Only good thing. Stability. Good six. I will take up the matter. Otherwise, you see, the exercise will be futile exercise. That is the reason. Because on the moment you conclude, I will decide it. So, yes, you will be wasting. If you say today, if you cannot conclude, so for some reason, if it is not concluded.
very unfortunate.
No, that is a different thing. That is a different thing. Whatever is there, I determination to that extent. Not today, go ahead, no. Oops. বেরিয়ে গেছে আমার কথা
Sir,
6. Hon'ble Sen is appearing.
Your Lordship, Mr. Amal Kumar Sen is not present in the court today, my lord. I am praying for 2 days accommodation, Your Lordship. My lord. No, my lord. Nobody appeared for the respondents, Your Lordship. My lord, kindly only 2 days accommodation, Your Lordship.
Lordship. Yes.
Yes, sir. My lord, 1st February, 1st or 2nd February?
2nd February, Friday, Lordship. Normally, audience. In terms of your Lordship direction, I have served. This is the evidence of service. Lordship, kindly daily supplementary was the month it will be 12, 13, 14, 15. Lordship, 15 matters will be there, then it will be problem. Lordship, any day month it is. Send supplementary list kindly. Lordship, issue involved, Lordship, regarding Lordship, pension is being affected, Lordship. What has happened, Lordship? I mattered that there is 2 schemes. Lordship, few matters are fixed matter which will take time, Lordship. That is Mr. Ghost matter. It will take time. That is the thing, Lordship. 6, 7, 8, any day, Lordship. 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 Lordship, service matter, entire service, current or old matters. We have not got that notification yet.
Well, then I'm appearing for the respondent, Mr. The petitioner, the learned counseling appearing for the petitioner was here yesterday, my lord. He had informed me that today some matters of him is fixed. So, my lord, yes.
On behalf of Mr. Kaushik Bhattacharjee, my lord, he left the court for his personal ground. I'm praying for not today, my lord.
13, my lord, I'm for the respondent. My lord, in 13, there is an affidavit which is to be filed. My lord, may I file the affidavit?
Respond.
I appear for the petitioner. My lord, I am appearing for the respondent, my lord. I am led by Mr. Vipul Kundalia, my lord. My lord, this pertains to, my lord, regularization of services. Lordship, we had already filed our opposition. The Lordship has the determined. In this writ petition, my lord, the 3 writ petitioners are seeking regularization of their services. Now, my lord, the writ petitioners are working with an office called Court Liquidator, which was formed for the purpose of overseeing the liquidation of banks under the Banking Regulation Act. The Banking Regulation Act was amended in 1953 to insert Section 38A, where this office was created. At that time, my lord, several employees were taken. Most of them were working on a temporary basis. But, my lord, in 91, a writ petition was filed by the then employees before this honorable court for regularization. My lord, because they had discharged services more than 20 to 25 years, my lord, they filed this writ petition. That writ petition was disposed of by an order dated 18th of June 1992, directing the respondent authorities to absorb the employees in regular service roles of central government. Because the pays are being regulated, the money is coming from the central government. So hence, my lord, Union of India is opposing this. My lord, thereafter, my lord, in the same year, my lord, that order of the learned single bench, the honorable single bench, was assailed before the honorable division bench. That the division bench, the honorable division bench, did not modify the order, my lord. That order was retained. Absorption order was retained. It travelled to the Honorable Supreme Court. Honorable Supreme Court said that central government, since you were asked to make certain regulations for absorption in the official liquidator's office, that you have to make similar regulation over here. That regulation official, the regularization of employees in the official liquidator's office was sometimes in 90. I'm asking for regularization of these three employees. Because here, my lord, equals are being treated as unequal. Court liquidator. Court liquidator. Because almost similar work under the central government. One is under the Companies Act, the other one is under the Banking Regulation Act. Court liquidator is under the Banking Regulation Act for the purpose of winding up of banks. I shall try and show your lordship why equals are some of them are upper division, two of them are UDCs, and one of them is a just give me a moment. Court liquidator. Lower division and assistant, the petitioner number 1. The other two are UDCs. Your lordship, kindly, my lord, we have already filed our opposition. No, my lord, there is something further to that. My lord, now when these three writ petitioners were taken under the orders of this honorable court, was given temporary employment, my lord. These three writ petitioners filed a writ petition. The writ petition was disposed of by this honorable court, not the honorable single bench, saying that you have to keep in mind the earlier orders passed in the similar facts and pass orders, relegated to the Union of India, my lord, government, to consider the application and dispose of in the light of the orders passed in the earlier writ petition. Yes. They considered and for extraneous reasons, showing extraneous causes, they have dismissed that. No, I'll show your lordship. I'll show your lordship. Yes, my lord. Which they were not supposed to consider under the orders of this honorable court. Yes, yes, my lord. My lord, I should be. My lord.
Sadly,
That is what.
sadly nowadays it's our fault that we really don't understand, either don't understand or we are not able to put it before our juniors what the meanings of particular words. No, it's our fault. My fault, I would say.
Not relevant. And they were not supposed to look into those. So this is what my entire case is about. His best case is regularization cannot happen. That's what I can.
No, my lord. I will take some time. I will take some time also, my lord, to give a reply. I have judgments. That apart, brief objection. What has happened? What has happened, my lord? He has. I think there are three of them. Three of them. Three persons were in the this high court court liquidators as part-time employees, and such employments were on the basis of orders of the court administrative decisions. And specifically, there are orders to that extent that these will be only for this purpose only. For this purpose only. And such advertisements were also made in that line. Thereafter, they come and say, no, you regularize. Now, thereafter, consequently, similar kind of matters went before Supreme Court. Supreme Court passed a certain kind of judgment where a particular cutoff dates were given for different cases. Uma Devi's case was there before that. Thereafter, this client's case. Correct, Uma Devi. Here it becomes a fact. Here, my lord, it's for the banks. It's a specific act. There's a specific act. Now, these employments are only for that particular company, which is in liquidation for that period. So that company will die. And it is for the death of that company. Yes. Yeah, not final order. In the company, in the orders with regard to that company for that particular term period that has been by which the appointment has been made. So that doesn't guarantee them a permanent employment. Yes. Yes. I don't think it is for several matters. I don't think it is possible. Yes. I'll have to see. Look into the facts. I will do that, my lord. I will. I'll do the factual part. I will satisfy my lord. That apart, my lord, these appointments were for particular duration of time. And consequently, there have been subsequently there's a judgment with regard to this particular division only, this particular department only, which has come from the Supreme Court. So I will place all these judgments before my lord in similar situation. What has happened, and thereafter post Uma Devi also there are so many other judgments which my lord is very aware of. I will do that. So my lord takes it up on another day. Let him place his case, and I will
In the meantime, in line with what my lord has put across to me, I will also look into the facts and come before my lord. My lord, my difficulty, my difficulty, my lord, is from 3 o'clock. We have this bench, original side bench in the revenue court, and almost. My lord keeps it any time towards the end of February. My lord. Okay, my lord. I understand. So if by chance if it comes in, my lord will kindly accommodate me. I will. You can take my. I. My. My. But not before that, my lord.
Suffering from quite some time, my lord.
এটা হয়ে গেল তো আজকে তো টুডে 30th January is over.
In fact, 21st and 22nd, I would not be here. Lord, your lord, because 21st and 22nd again, I will not be here.
Okay. As whatever, my lord. Just if by chance I am on legs, my lord, because it takes a lot of time to walk from the perspective. I'm grateful, my lord.
Junior to right. It will take notes. মামলাটা করতে হবে নোট তো নিতে পারবে তারপর যখন তুমি বলবে